Good morning to one and all present here. My name is IICA. I'm a third year law student at BITS Law School. Dr. Chetana Lal is a seasoned legal professional with over 20 years of multifaceted experience in law, including litigation, corporate compliance, strategic legal advisory, risk management, and gender justice. She holds a doctorate in law with her research focused on reproductive rights and surrogacy in India, a reflection of her deep engagement with evolving policy and legal framework. With over 14 years of active litigation practice, Dr. Lal has successfully represented clients in complex matters. Her legal acumen spans contract law, negotiations, family law, domestic violence cases, and regulatory compliances. In her academic leadership role, Dr. Lal heads the industry collaborations and career advancements at BITS Law School, where she works closely with legal firms, corporate houses, and institutions to bridge the gap between legal education and professional practice. May I now please invite Dr. Chetana Lal. Thank you.
Thank you, Atish. A very good morning to all and happy for joining us today. On behalf of Brits Bilan at School Mobile, it gives me immense pleasure to welcome you all to this town KV. Corporate commerce combines in Paraguay India's evolving media and sports ecosystem. We are confident that today's roundtable will foster insightful dialogue and lead to meaningful and productive decisions. Bitslow School carries forward the legacy of Fritz Pilani, an institution renowned for academic excellence and innovation and strong industry engagement. Our law school aims to equip students with the knowledge, skills, ethical grounding required to navigate a dynamic and evolving legal landscape. At Bits Law School, we are committed to creating meaningful platforms where industry leaders, legal professionals, and academia can engage to exchange ideas and shape conversations that matter. Today's roundtable is a reflection of that commitment. We are deeply honored to have with us our keynote speaker, Mr. Anand Desai, whose contribution to the legal profession had been exemplary. We are equally grateful to all our distinguished speakers for generously sharing their time, expertise, and experience with us today. I would also like to extend a warm welcome to our moderator, Mr. Samicho, as well as to our faculty members, students, and all invited guests. Once again, I thank you all for joining us and for being part of this important dialogue. I now trust Ayush Datu to kindly introduce our chief guest, Wisami Desai. Thank you.
Mr. Anand Desai is the managing partner of DSK Legal since it was founded in April 2001 and has helmed its journey to be recognized as a top tier firm. Acknowledged as a leading practitioner in India, Mr. Desai has over 40 years of extensive domestic and international experience being a trusted counsel to several large multinational Indian corporates and high net worth individuals. He has developed a strong track record of successfully representing high-profile clients in criminal and civil litigation, and has succeeded in getting several large commercial transactions concluded across a wide range of industries and geographies. Clients value his innovative and strategic inputs along with his pragmatic, result-oriented approach to optimize their strategy, particularly when facing crisis situations that include adverse press and social media coverage or potential criminal law consequences. He has been appointed as a member of the court at the London Court of International Arbitration and was appointed by the Government of India as chairman of a committee to recommend amendments to the Specific Relief Act 1963, which was duly made into law. He's involved with several industry organizations, trusts, and NGOs, and is recognized as a thought leader by Lexology and an eminent practitioner in Chambers Global, amongst several other recognized and awards. Thank you so much, sir, for joining us today. It is my humble request to all guest speakers, while speaking, please use the mic, or since the session is being recorded, or else we'll lose your valuable inputs. Thank you so much.
Thank you to BITS Pilani, thank you Law College, thank you Khozam, who I've known many years, and many friends here I've come across in practice, normally on the other side, but sometimes doing transactions together. I think it's a very topical subject you have chosen, and underrated subject as well. The variety of work available today to lawyers is so different to what it was even 20 years ago. We were considered litigation or non-litigation, civil or criminal, or tax or labor. Some did constitutional, and then there was some general hazy IPR. And as IPR developed, that side got more and more focused with IPR specialist firms, etc. I'm not sure what each of you understands by media law. Internationally, media is a very wide subject. It covers every form of communication, whether it's print, television, online now, which is newer, films, and I can go on. Then you have sports, and there's, for some reason, an interlinkage between sports and media, primarily brought about by a gentleman many years ago called Mark McCormack. I hope all of you have heard of him. If you're getting into this field, he's the man to look up to. He's written books, including what they don't teach you in Harvard Law School, etc. Very interesting journey, and this may give some insight to some of you as to what opportunities come around. He was working as a lawyer in a law firm, I think it was the late 50s. At that time, there was a famous golfer in the United States called Arnold Palmer, who had become like a bit of a legend in his career. Professional sports was much, much smaller in those days, but he had become like an icon. The only communication methodology at that time was newspapers, if you look back at the 50s and 60s. Television came around that time. He decided to quit his law firm and to professionally manage Arnold Palmer. Unheard of. What he achieved for the system, and I call it a system because it's an entire ecosystem, environment, etc. Many years later, 1980 or 81, I was in London. There was a big article as to what he had done to bring professional sports up to the international standards, popularity, prize money, television coverage that was prevalent by this time. He was managing Wimbledon tennis, as an example. He used to manage the major tournaments around the world for tennis and golf, which were at that time the highest money spinners. He arranged the Pope's visit to the UK, including security. Why? Because his ability to administer and implement a system that he had effectively developed. His company is called IMG. There's an IMG branch here. He's passed away as far as I know. But what I'm getting at is all of us look at opportunities as being doing better than the next guy in what everybody's doing. That has its own advantages. It also has limitations, because somebody else is going to be cheaper or quicker or slightly better in what that standard is, right? So can you think out of the box and do something different? And as students, I would really encourage you. The world is so much wider now. There's so much more opportunity. So point one I would say is, as both faculty, people like us who are engaging with youngsters, working with youngsters, number one, do not limit your vision to India. Both these areas, media and sports, are far, far bigger outside India than they are in India, I can assure you. Take sports, take an example. UK, most sports are administered by the government. Here too, we have a BCCI, but today BCCI is sort of become in control but subordinate to IPL, correct? IPL has become so big. IPL draws the money. They still report into BCCI because that's the governing body. You got a football league, kabaddi league, etc., didn't have these 20 years ago, 15 years ago, 10 years ago. One by one, more and more are mushrooming. There's now a rugby league. There's paddleball, pickleball, sports we never heard of, not long ago. There's a federation at the sports ministry level. There's a new act as well in India, as you know. But like I said, the more you can think about innovation, take gaming. And the whole controversy that started on online gaming, which also had the element of gambling, which has now been banned. So there's the non-contentious work, which is evolving very quickly, breaking down into segments every aspect of the transaction, the rights that the champions have in each field. You may have been reading about personality rights litigation in the recent past. The concept is not new, but the spread through the internet of potential loss to the celebrities is new, relatively. So television was step one for a mass distribution, because otherwise in newspapers you have to advertise, which costs money. Television you have to advertise, but news anchors would talk about some of these things because they would get more publicity. Then you came to the internet and the ISP, Internet Service Providers, license conditions, which are not very strongly enforced even today. There's a requirement for them to not allow pirated content, not allow content that is in violation of copyright, etc. When piracy started on the internet, earlier, if you remember, it used to be piracy by people giving you CDs, DVDs. It then moved to the internet, where it's rampant, and there are websites proclaiming that they are showing pirated content. You may also know, in the same field again, there are official sites today on the internet selling officially fake goods, claiming that they're fake goods. You can buy a Patek Philippe watch declared to be a fake Patek Philippe watch. And the justification is, since I'm declaring it to be fake, you can buy it at a cheaper price and not competing with the actual brand. But that requires a sophistication in the mind of the customer or the consumer who will understand the difference, right? It's the same thing on the internet. I see an image of a celebrity associated with a particular product or service. Is he endorsing it? Is his image being misused? So the whole range of things which are evolving, they'll keep evolving to my mind. In sports, again, just to give you a sense as to the range of activity, the formation of a sports body. We just formed the rugby league. It's already facing litigation. I've got a partner currently sitting in Shimla. Why? Because the Himachal Pradesh association that got recognized by the Indian Rugby Association is challenged by another lady who says, no, I formed the first association, I should be the one over there. So there's both the establishment and the litigation that comes about just in the formation stage of the association for the sports body. There are rules, regulations, disputes. I met an interesting gentleman about 25 years ago, Swiss lawyer, who very proudly told me that he represented the legal side of the Olympics. So I said, what does the legal side of the Olympics mean? He said, well, if there's a controversy, for example, an allegation that an athlete has consumed drugs before participating, or there's a question as to whether he's broken a rule in conducting himself in the race or whatever, there's a team of lawyers that actually is sitting there and they have to give an instant decision. We've seen it now in India in some cases. You see it for is the cricketer batsman out or in when the replay comes, and some gentleman, you can hear his voice, you can't see him, correct? Is he a lawyer? I don't know. He should be a lawyer, is the way I would look at it. People think that, media law was always there. I can tell you 1992, I started doing work for a gentleman called Amir Khan, who was a known actor but has become a big actor now, big celebrity. There was no concept of an acting actor celebrity contract in those days. There were professional models who did modeling. There were actors who did acting. It was pretty much not possible to see an actor in an advertisement. The Bollywood set of people were all like one big family with lots of nepotism. Andhra is still to that some extent like that. That's the second biggest market, as you know, maybe the biggest market now. Tollywood is similar. He decided he wanted a contract, which is why he came to me first for litigation, then a contract, and we sort of set a bit of a trend to start contracts. But things changed when the Hollywood studios came and set up here. Warner Brothers, Disney, etc. They cannot operate without contracts. Part of the reason also is, I must tell you, in the US, contracts are pretty much all-encompassing because there's not too much law to support activities that people indulge in. In India, we have a lot of laws. I'm a firm believer that in India, contracts became as thick as they are because we started following US precedents, not realizing they're US precedents based on US law and don't require to be imitated here because we have got a whole bunch of statutes that support a lot of activity. For example, Transfer Property Act, Sale of Goods Act, right? All these give you a lot of rights and obligations that don't exist on the statute book in the US, or at least did not till some time ago. So I would encourage all of you look way beyond what you think could be viewed as meeting celebrities. That's not what media law is about. It may be part of it. We get a lot of applications to join our firm. Diva, my colleague, reviews some of them. She's in the media team, I'm not. I just come in when required. But most young lawyers think, oh, I'll come and meet lots of celebrities, hence I want to do media law. It doesn't work that way, simply put, okay? There's a whole host of activities but that go into both the regulatory, regulatory, tax, I would say even GST today, structuring a transaction, stamp duty. There was a time I remember when licensing a right had a higher stamp duty than assigning a right. So some bright lawyers said, let us do assignment documents instead of licensing, not realizing that it's gone then. And the poor celebrity, etc., thought, I'm saving money today, who knows what's going to happen tomorrow. So structuring a transaction of any sort is critical, which is a huge value add. Acquiring a portfolio of intellectual property that arises from either media or sports. As you know, today there's a lot of consolidation in the market. The three players effectively in the film industry who are financing, in Bollywood at least. As that happens, they're accumulating rights and developing value. A library, so to speak, of films has value. How do you get a valuation done? You and I can't do it, I can tell you. There are specialist valuers. Who interacts with them to determine the way in which it is done? Lawyers. So like I said, wide open field. I know there's going to be a long discussion, so I don't want to take up too much time. But all I would suggest is really widen your thought to a global level, soon to be space level to my mind. I'll just leave one last anecdote as to how the legal system has functioned in the past. Primarily because people did not understand how technology would change things. So till a certain time, I think the 70s, films would be exploited in only two ways, in a theater, and the music on what used to be called vinyl records. Some of you may not even have heard of this concept, but they used to call us 33 LP, 78 LP, etc., which you would buy and play on a little machine with a little needle that would read the music and play it on a speaker. When home viewing started, first through television, a debate arose who owned the rights to grant it to the television channel. We only had Doordarshan first, but then other channels started coming up around the world. Then came VHS cassettes. Who had the right to grant the music, the entire film, clips from the film for advertisements, which could now be played on television or could be played out on other media as things evolved, including on CDs. You would get a CD with a little advertisement at the beginning, and so on. With this arose moral rights. As you know, in the Copyright Act, we have moral rights for people who have given their acting rights or singing rights or lyricist rights. Then came another amendment to say that the script writers and the lyricists who write the lyrics should form an association and be entitled to royalty going forward. This was driven by a set of people in the industry, but they required lawyers to deliberate on it and to draft it and the legislature to pass that. So it's a very quickly evolving field with technology like many other areas are. So like I said, don't limit your thoughts to what it is today. Don't limit your opportunities to competing with the current set of lawyers and what they're doing. I can tell you as we get older, you are the ones who will have the new thoughts. You are the ones who will have the new ideas as to how to exploit differently. Last example. Cricket is played in a stadium. Football is played in a stadium. How many of you have noticed that around the ring of the periphery, there are advertisements all over? That's called in-stadium advertising, didn't exist earlier. There are similar payments made to a producer of a film to have the actor drinking a Coca-Cola or whatever else. He's paid for that. These are all breaking down the rights, breaking down the opportunities more and more and more. Why? Because the overall numbers at which these films or rights are being sold is increasing. Thank you. I'm around for some time, so you can ask questions there.
It is my honor now to introduce our moderator for today's session, Mr. Sameer Chugh. Mr. Sameer Chugh is a seasoned legal executive and compliance leader with over 27 years of experience in corporate law, governance, regulatory compliance, and mergers and acquisitions, currently serving as the Chief Legal Officer and General Counsel at Games 24/7. In this role, he leads the company's legal compliance and governance functions, drawing on deep expertise in compliance in complex legal matters and strategic advisory. Throughout his career, he has been recognized for his problem-solving approach and ability to align legal strategies with business objectives, leveraging his experience across diverse sectors and jurisdictions. Thank you, sir, for joining us today.
Okay, thank you. No, thank you for that, and welcome everybody. I think we'll keep this session interactive. This is not a question and answer for sure. I mean that, kind of I'm asking the question, but I think I would request everybody to be as participative and kind of, if you need to jump in, please jump in. I'm not perfect either, but I did put some things together with the thought of, how we should really deal with the issues. At the end of the day, and I've been talking to the faculty here as well as the students. Before anything else, I must acknowledge some of the students who worked with me on this to prepare for the questions as well as some of the background. So just a round of applause for them. Thank you, guys. And so they also accommodated me late night for the calls, and they were like, okay. so we have where we are today. And the whole intent is at the end of this, we want to convert this into a white paper, which will at least state what the issues are and then, what possibly can be done, with the intent of then trying to submit it to the relevant authorities to say this is what, kind of the industry, the lawyers, the stakeholders really think of. So thank you, Anand, for the, background and the history. And yeah, it was when you were talking about it, I was just wondering that the LPs and all of that, I mean, obviously none of that exists today and people just threw it out. As a just, kind of a matter of reference, the other day we were doing some attic cleaning. Yeah. I found some VHS tapes. So we threw all, I kept one, saying, this is something you should just kind of keep it for just, kind of remembrance and stuff, it's there. So having said that, I think, kind of we can just dive straight into it, and I'll just give you, state a little bit of context here. And the whole idea is that if you look at, kind of the topic per se, which is essentially, to say that the content, commerce, and compliance, and navigating India's evolving media and sports ecosystem. Now, when we were looking at the topic, I see there are three areas really, and there's media, of course, which kind of on its own is a big area and kind of encompasses how the world has moved or etc. And then the fact remains that if you look at some of the media laws today, I mean they have been pretty old, and we kind of, if you see, I mean the whole idea of where the media came in was a freedom of speech, if you go back into the history. But clearly freedom of speech was then also in a way somewhere kind of exploited, and then the freedom of speech went beyond a certain point, which was not acceptable per se. But there were also, and that's why 19.1 gave, freedom of speech, but 19.2 also said there can be some restrictions, but reasonable restrictions. Now that's a different issue in today's world, from reasonability to what it is. We've gone all over the place, and then earlier it was pretty much just print and newspaper. But now with the whole digital media and what you're free to post, and the way the Insta and the Facebook and everything happens, I mean, the number of, I was reading this and my statistics may be wrong, but in terms of percentage, the number of defamation cases in the courts have gone up by some 30,000%. So earlier it used to be like a few cases in a year. Now you pretty much have defamation cases being filed pretty much every day. And a lot of it is because of the whole social media and the digital media, where whoever wants to say something does it without realizing whether it's really crossing the line or not. And then, if you go into it, then for the print, there were laws like the whole, kind of Press and Regulation of Books Act, and then Registration of Press Council Act, the Contempt of Court Act, more from the perspective from a defamation, while defamation still as a law has got its own gray areas. And then when the electronic media came in, you had the Cable Television Regulation Act. That was the only media that was there. And then post that, there was the Prasar Bharati Act, and then there was some broadcasting regulations. IT Act came in, and then the IT rules came in. All of that was really to try and regulate how the information, etc., is being dealt with on the information, on the social media and the OTT platforms. We saw a stage where OTT came in. OTT had pretty much a free run. They could show anything they wanted. It was almost, it wasn't just crossing the line. It was almost like way beyond the line. And then there were regulations that came in. There are more regulations that are coming. But one of the big questions is that enough really? And I think that's a big gap, and really a real regulation is not there. A lot of it today depends on self-regulation. So one of the pieces which I feel we should really talk about is the whole regulation versus self-regulation, and where we stand, where we ought to be going. And, so that's really, in a nutshell, if you look at the media side, there is outdated laws. There is a huge control by the executive. That's the reality. You got to be careful what you say, and therefore, you're being watched. There are now areas where they say, because it's commercial in nature, that's protected, and therefore I should be allowed. But to what extent does that go is another question. And so what do we need really? Maybe reforms, maybe new things. That's what we really ought to be coming out with. So that's on the side of, when you look at really the media. And at the same time, if you see sports, now that is an area on its own, right? From physical sports to really now to digital sports, esports. We've just seen the whole advent of how the online gaming piece went away. It came in as a bang. It kind of continued. It became a huge industry, generating some 20,000 crores of GST every year. But then there was a crackdown, and one fine morning, everything just stopped. But having said that, there's a new act now which does allow esports, but the rules, etc., are still trying to be figured out. So and then of course, you look at some of the other places where how you have the latest thing, which is the whole national sports policy which has come in. To be very honest, it really is focusing, if you see, on 5 core pillars, which is very global excellence, economic and social development through sports, making sports a people movement, and integrating sports with education. There are countries, you spoke about that, there are countries like South Africa, Australia, UK, US, who have specific laws for that, and they encourage. And one thought of me said that, and that's why they win far more medals in Olympics and the Asian Games and all of that, versus what we are, despite us being, even China has a specific law, versus us being, the most populated nation in the world, yet not able to get, even as a percentage, maybe, the number of medals. So to that extent, clearly, I think the whole NSP, which supersedes the 2001 policy, is a step in that direction. And we talked about a bit on the electronic sports as well. So that's really where it is. And therefore, to me, the cusp of all of this really goes back into what is really the sports media ecosystem. So that really came out as the area. Now, we could talk about media, we could talk about sports separately, and then there is this part which is linked, and that really goes around the fact that how do you then turn around, kind of really say that when you're talking about sports broadcasting, right? How do sponsors, how do companies, how do these sporting companies, what are they? Are they sports companies? Are they sponsors? Are they broadcast? I mean, how do they kind of then broadcast? Are they using their sponsorship for advertising, or are they using their, kind of involvement for really development of the sport? I think all of those places are gray area. Obviously, everybody is looking for a commercial benefit, no doubt, because you don't do business for charity. I mean, there's a famous saying, I'm forgetting who said it, saying if you really want to do charity, then you don't get into business, right? And that's what it is. So having said that, I try to put some of the questions out there. I added some more questions. Sorry, some of those are not with you. But I just thought, it'll just kind of give us a good, way to look at it. And then we can kind of just step into it and go. Now, I am easy, subject to whatever everybody wants. Do you want to go into media first, or is it okay we go random? I mean, just wanted to check with people. No, but whatever's the comfort. So, because I want to make this as interactive and as meaningful as possible, because, I mean, there's a lot of time, and I see, kind of all the busy people spending time coming here. I mean, it's a lot of time that's being put in, so let's make this meaningful.
I think you circulate a few flow of questions, we can go with that.
Okay, sounds good. Perfect. Okay, so I think, then if we were to just look at it, then if we just start really on the, sorry, I'm a bit all over the place here, but that's how I like it. So let's start with the media first to that extent. And, I just want to also kind of talk about from a media and sports law, how it works. So, and then I don't know if you want to, I mean, how do you want to do this? Should I direct the question to somebody, or do you want to just volunteer and say that this will work? Okay, all right. So I think, kind of the first thing, maybe, can I start with you for yeah? Okay, thank you. So, see, and this is also because you're a wealth of knowledge, and I think people will benefit there. See, if you look at the current media and sports law, right, and the technology, the way it's happening. So there is sports, there is media, there is broadcasting, and then there is a whole OTT-driven part. Where do you see the intermingling of this, and what do you see as the biggest challenges over there?
Thank you. So you're right. In all law, the law is a catch-up by definition. There's no law before something happens. It's like breaking a lock. Nobody makes a new lock till the old one is broken. The speed at which technology is developed, I find, is just incredible. To have online fantasy games, for example, is something unheard of. The television industry, I think, was able to demonstrate that self-regulation can work. So while you have the Cable TV Act, or law, rules, whatever, yeah. It's really a framework, and within the framework you operate. I'm also a firm believer that over complicating a regulation or an act is counterproductive. And the standard example, at least I gave, if you look back at the Contract Act, Transfer Property Act, etc., which have been around from the 1800s, they provide a framework, and it's survived till today and can be applied to multiple situations. The moment you become prescriptive and start putting above 1 crore this and below 5 lakhs that and all that, it just becomes a mess. And because the 1 crore changes value, as we've seen, the 5 lakhs changes value. So I would say if the government is doing something, they should put a framework in place that is adaptable to any of these situations, which is really a broad set of rules. Those rules apply. If you break the rules, you're in trouble. If you don't break the rules, you're fine.
So maybe on this, Shivals, do you want to kind of add to this? And
Thanks, Amir. First of all, BITS Law School for a nice seminar today on a roundtable. It's quite good for a lot of people from diverse industry backgrounds, stakeholders to come here. So on that note, I fairly agree from the first point that laws are always there. I think it's a question of implementation. I think there are 3 ways in which I believe every law is implemented in India. It comes from a basic law, there are rules, notifications, and then come the judicial precedents. I think over the period of time, every industry sector in this country and most of the regulated one. So I had the fortune to work with the telecom, media, airports, e-commerce and real estate, which are quite regulated industries over the last 15, 20 years. And what I've found is that law has been as rightly put by Anand, is a catch-up domain. And the other aspect which we need to deliberate today would be what kind of regulation is required. Internationally, there are two phenomena. Either is the soft touch or is the full hard regulation, and in between comes forbearance. Forbearance is that you put a certain basic regulation in place, let the marketplace take decisions, and if there is some aberration, the regulator steps in. So that has been the international perspective of having a forbearance-driven regulation. That has been very successful. India, when it started in telecom for the first time, they started with a bit of high regulation and they pulled back to forbearance, and you saw the industry growing very well, right? Unfortunately, when I saw in media, overnight regulation came and they stringent, in fact, content, the tariffing of content was got in. It was like an essential commodity. So I think if you know 2004, the price of channels that were there today for any individual or a customer to take was freeze for over next 20 years. The content cost increased 100 times, but the tariff which went to the final customer was freezed with maybe index-based 1%, 7% increase. So I think the biggest challenge which I see in all this period is if the laws always exist, and if you look at it, like the 1885 Telegraph Act was such wonderfully drafted that even when the interpretation of GSM, CDMA technology issues came, the language of the legislation was so good, it could come. So I think one important takeaway I will feel is that legislative drafting is something which is missing in the last 2-3 decades. We have not seen legislations which are quite good or stood the test of time. So I think that's one area definitely we need to look at it. Number two would be, I believe when it's a regulated sector, who else becomes a regulator is very important. Internationally, if you look at the European, US and certain Southeast Asian markets, the regulators, people are those who have worked in industry for 20 years, they come up, become the regulators. They understand the industry perspective. I think that's one challenge which needs to be addressed. The last aspect which I will say is that every industry which incorporates self-regulation, I think has been able to withstand the regulatory pressures from the government side. So to start with media, when IBF was there, they had the self-regulation mechanism. So they were able to keep the MIB a sort of time to test them because they were doing certain things. Whereas when I was in telecom, there was no, the industry was fighting. So I think one concept is you save the platter from a government overreach or regulatory overreach and fight the market in the market. You don't go and fight in the regulatory domain. So I think three aspects which come is, one, regulatory regime is one you have to look at how it should be. Number two should be laws exist. I think what it requires is a good implementation. How good the industry interacts with government, has a self-regulatory mechanism, will go a lot of way in defining how an industry prospers. So I think somewhere like the online gaming, I think it was a out of the blue hit for many of the players in the market to see suddenly zero revenue from a, crores revenue happen. So I think these two aspects are there. And lastly, lot of sectors have gone to a tribunalization. It's from the courts, they move to a special tribunals. I think as a concept, you have to see whether we need so many tribunals or we need 3-4 tribunals who specialize in certain aspects and they do that. So TDSAT works as a regulator for the telecom sector, media sector, and now for the DPTP Act, they are also the one of the tribunals. So I think one needs to restrict the tribunalization aspect, otherwise in multiple tribunals, I think the judicial precedents will not go that manner. So I think on these count, I would like to give my views.
Yeah, Mohit, but just I want to just add one piece to it, and I don't know if you have a different view, but I mean, I hear what Anand and Shivaji are saying, but also remember that if you look at, kind of a lot of industries where you left it to self-regulation, they took it to an extreme, right? So therefore, while I understand that the Contract Act kind of, withstood the test of time, but the way the things have changed today, right, and the way the changes are happening, which is pretty much on a real-time basis, I don't know how many more laws can ever, withstand the test of time. And given the fact that, kind of from the competition and from how the commerce has evolved, people are willing to, I mean, there was a saying, and I always learned this saying, we push boundaries, we don't cross them. I think it's changed. We only cross boundaries and then we make them new boundaries. I mean, that's one way to look at it. Some people find it okay, but some people don't. So just that aspect also, if you can, kind of add into, in addition to what you're going to say.
Sure. Thanks, Amir. I just want to build, on what Anand Bhai and Shivals and you added. Just as a background, I was in-house at Disney Star for a decade, and so started with, on the media side, which is TV, the regular thing. So the point I'm trying to make here is within the same organization, but handling different business units. So from, buying, content for English cluster, move to sports, and then to digital streaming business. So within the same organization, I was dealing, with different laws for different, again under the media head as well. So I think I completely take your point. It's time for convergence. Why should a law, be it on, satellite television and on internet, they should be different rules and regulation. It should be, for example, like Copyright Act. It applies, without any, bifurcation, if I may say, whether it's the medium is internet or a TV. So, I mean, it's very interesting, as Anand Bhai was saying, that there's Cable Television Regulation Act, which applies only to TV. Well, when you enter to sport domain, for example, the media rights, as you were talking about, billion-dollar properties, you have statutory requirement to license to the government of India, for Doordarshan. The acts comes into play. So I think, why don't we start thinking something like we do for patent drafting? When a drafting is done, you foresee how the invention can be done in a manner which takes care of possible circumvention or possible, how do you ensure the specification is broad enough to cover other, the length and breadth of it, for that matter. Just an example, for example, if I am, today writing a specification for fan, I would not say 3-blade fan. I would try and keep it wide. So why can't we foresee the law coming up in a manner which goes beyond the present fact, so that it kind of takes into consideration for the tomorrow? I think that's a little bit is what I would like to add here. And self-regulation, just to tell you, I mean, the way I see on media side why it actually came about is because, CBFC frankly didn't have the bandwidth for, the TV soaps that which were coming out. It was eventually taken in-house from that perspective. IBDF, IBF at that point of time thought about it, and self-regulation to a great extent, it has helped the industry. Taking away the load from government because they didn't have the bandwidth, and at the same time, now with digital content, of course, imagine Cinematograph Act for that matter is still a question, I would say, but the understanding it doesn't apply to digital, platforms. Very interesting. Why is the question would be. So I think those gaps, because we aren't able to foresee, at time of drafting of the legislation, what could be the tomorrow need and modes. So those are the things I think if our legislatures, look into it, will be very helpful, is I would like to add. Thanks.
Thank you. I'm going to, just take this piece and I'm going to go to Manisha here. I mean, you've seen, I mean, you're an ASCII, you've seen in a way, I won't call it fully self-regulation, but in a way it is a form of self-regulation where people are, and the industry works with you to say, okay, this is what we should add, etc. But in real terms, I mean, your view on, is it really working? Because the amount of complaints that you get, I know, is humongous. There's still people who flout all of that. And so from a real perspective, do you see it really working, not working, gap, somewhere in the middle, evolving? What's your thought?
Yeah, thanks. So I think, the advertising self-regulatory body, ASCII, has now been in existence for about 40 years. So in a sense, it's also a long time to kind of reflect on things that have worked well and perhaps what, could be different or what needs to change. So the question is that what would you define as a success of self-regulation? Yeah, so I think the first thing is that you want to keep formal regulation away if possible. If not, then you wanted to closely reflect what self-regulation already does. So for example, one of the successes that we would look at, specifically if I talk of ASCII, is that, for example, we are included in the Cable TV Act. The new CCPA rules, when they came out on misleading advertisements, were pretty much templated on ASCII's own codes. And therefore, that is also, I would say, a success of self-regulation because, the way you are thinking about the codes and the law reflects the way, in a way you have a template from the industry which is thinking about itself. And, so that makes it useful because you are not now, you have a law which is very different from how the industry is imagining its own self-regulation. I think having said that, I would say in the last few years, the amount of fragmentation that is happening on the advertiser front, on the brand front, and pretty much anything that you look at it, there is, right now you have a very, very long mid and end tail, as industries grow. And what I think really works well in these matters is actually co-regulation in some way, which is that the self-regulatory bodies, we always say, do the work by exertion and let the government do the work by exception. But even that exception needs to kind of be there for, implementing when it comes to willful offenders, when it comes to, people who are constantly, kind of flouting the rules or making it difficult for others to work. So I would say, in some way, co-regulation, I would say, is the ideal kind of, situation. But yes, I think everything is evolving so fast, everything, so self-regulation also allows you to be much more agile than regulation does. So I think these are some of the key, I would say, advantages of self-regulation, and therefore, by default, should it be the first way in which industry thinks about, its own governance? I would say yes. I would say that's a very strong kind of approach for industry to take.
Yeah, I just want to add, to what Manisha said. I think it's a sign of mature economy, mature, organization. It's time we move that path, I think from that perspective. And Manisha, correct me if I'm wrong, what I recollect, even for, brand extension, that part for some reason doesn't lie with ASCII. They kind of bring it up with MIB, and for them to take an action sort of a thing. So that, bifurcation, from that perspective is again, unwarranted, I would say. There should be one.
So there is CBFC which looks at it for TV, but they don't look at it for anything else. So when it's on print or on media or on digital, then we look at it. So you're right that,
Yeah, I mean,
it doesn't lie in one place.
yeah, that's a little weird at time, and it's I would say that's one thing that government should be looking at. One-stop shop for everything. I mean, a clarity, from that perspective. Thanks.
Which actually leads me to the point that, kind of the broader, larger question, because if you look at, today, you see, kind of, you have these three things, right? You have the print, you have the media, you have the broadcast, and then you have, the digital piece. So like different. Actually, while, kind of they're communicating, but the fact remains all of them are very different, and especially the kind of content that they have and what happens there, right? Now, the biggest challenge that I see is that if you look at our framework today, right, I don't see the framework really being able to deal with all of them, which means that there are gaps everywhere, right? And the fact is we're always doing this catch up. And the reality is, and when we started, and Anand also mentioned that the way technology is moving is just unbelievable. I mean, to be very honest, and I'll just give you my own example. I mean, the gaming industry kind of went through whatever it did. Within like months, everybody in the gaming industry has moved on and they've gone and pivoted and done other stuff. And it's only based on technology. The reality is none of these companies have anything which is an asset other than tech and basically people, right? Now, so they are now moving, there are new things, and there is no boundary to thinking, which means that it goes back to the point saying that do you keep taking different pieces and then try to regulate them, whether it's self-regulation or it's a law? Or do you really need to take a vision to say, okay, what's going to happen now? We're sitting in 2025, 26 now coming in. I mean, somewhere I feel we don't think saying that where's 30, where's 40, where's 50, where's 60, right? We're all very short-sighted to look at it. So should it not need, and I think this is a question I want to ask everybody in the room, right? And we can do a quick round there. Is that a unified regulation to deal with areas which may be connected, etc.? Is that the need of the hour? Or is it like self-regulation only, let people decide what they want to do, and then the government can come in whenever they want to? Or do you still go with the fact that on certain things you will need laws, you'll have to have a different approach? So just maybe we can, kind of from that perspective, can we maybe start there? Munir, can you start with that?
So thank you, Samir. Um, if we see, there's a huge shift of coming from the television background, the traditional television background, to the mobile era of where we were watching television, and now we are watching television on mobiles. That shift is essentially it's because of the widespread internet, cheap data, everybody having a mobile in their hands. And when we talk about laws, yes, there is a lot to catch up. And when we again speak about law, there are laws, and Anand Bhai, of course, will vouch for it. There are laws for which there are laws, and there are laws which are passed by way of judgments passed by some judges, in which there are no laws, and those judgments then become laws. The judicial precedents, they become laws. Now, sometimes that's the interpretation of that judge about a law which is not in existence at that moment. Having a framework for certain things, I think, would actually, I know there's a lot to catch up. This industry is moving very, very fast, and bringing up laws for everything and every step would be a little difficult to catch up. But I think if there is there are laws which are there for certain aspects, that would help even for interpretation, and you are not then dependent on that one person delivering a judgment. On self-regulatory, yes, it is a good concept, but enforceability again is something that one needs to look at. Also, what would be the appellate authority to look at that enforceability angle as well? So does that become a diktat, or does that become a law? So I think that's my two piece on this.
I think it's going to be, given the pace of technology and how it's happening, it's next to impossible to say that a one-piece legislation or a framework will apply to all. When we start with, if you look at the current orders of OTT itself, we had an electronic media, there were regulations around that, but not applicable to them. There was telecom laws applicable to them. So it all depends. End of the day, it is the industry which is making the lot of money, grabs the attention from the regulator and the government, and that's the hard part of it, and it starts from there. So I think the starting point would be, I believe, regulations need to exist, but they should not be an overkill. You cannot frame a law to cover various overlapping sectors of industry perspective. There are, like, if you look at the basic issue, content in maybe a media industry versus a tariff regulation, that itself is a big piece, you can't say, or CCI versus a regulator perspective. I think it itself going into a big piece. So it's going to be difficult. What we require are very good judicial precedents or principles on how these issues should be addressed. And that has been growing. So we had, if you look at over a period of time, we had very good judgments coming in various areas. Like in telecom, you had this at whether a regulation can overreach the licensing powers. So I think few good such leading principles in judgments will help us do the thing. It's not possible in the speed of technology to have one regulator or one law to look at it. It has to be multiple. We may have to look at multiple things. A basic licensing framework, which will look at how a certain operator will operate or a sector will operate. Second will be some guidelines, how they should operate in their various areas, which may have how it will impact maybe the kids or the social media, how it will become to a defamatory or versus. But I think the aspects need to look at that. And lastly would be, we will still want, in my view, the courts to decide with the judicial precedents on what is good and bad, rather than start with. And if we have a self-regulation, nothing will. My view, across industry I have seen, a self-regulation always helps you put certain perspective. You will put a stop to where the government or the regulator comes, because what happens is the data sharing from the industry is very rare when they go to a regulator. So they don't want to give their complete business game to them. So you are less in sharing data. So it's very difficult. So when you do a self-regulation startup, you will come with a defined, because you are the industry players, you know how it operates. You will give a framework where to look at it. You will draw the lines, where to cross, where not to cross. And I think the most important point, which I think, Manisha, where ASCII comes, I would like you to highlight is, even though when it comes to ASCII self-regulation, people appreciate it, the moment it goes a certain way beyond, they challenge the role and say whether they have, they can regulate me or not in that sense. So I think that is one aspect where if you look at judgments on the ASCII side itself, there are pros and cons whether they are binding nature or not. So if some good regulation comes or a judgment on that, how self-regulation can be implemented, I think that will have a rather impact rather than framing laws.
Yeah. So I agree with what Shrival just said. There should be, I think, a combination of a self-regulation, then a regulator, and then courts. Because overburdening the courts with everything is again going to be not in the interest of everyone. So, for example, we have to also look at it from the what we are regulating. For example, we are a radio industry, and we are only audio-only content. So there are different impacts of a particular ad when it's on radio or when it's in an audiovisual medium. Okay, so there cannot be a umbrella legislation which can look at all type of content. Recently, I think there was a bill, broadcast law, which was going to consolidate all the mediums, and there was a lot of pushback from the industry on that, because obviously it had certain kind of regulations which did not suit, for example, a radio medium. So there are different aspects of how much an impact a particular ad can make on the audience. A visual impact is more. Then currently, yeah. So currently there is no self-regulation mechanism in the radio industry as such, but still we have an association of radio operators who interact with each other. We decide what kind of, we set the rules, which kind of ads can go on air and not. There are regular notifications from MIB which we follow. So currently there is not much of a tiff, not much of challenges which come up, and the industry is quite matured in that sense. But self-regulatory body can always help. Yes.
Yeah. Just to quickly add, self-regulatory body like ASCII, which has a statutory recognition under cable television rules. So that is, a good step forward. Regulatory, self-regulatory plus statutory recognition. That is a position that what we should be looking at. Giving them that, sense of responsibility and maturity is what I just want to add. Thanks.
Yeah, no, I sort of have a differing view. I was looking for something like that. Only because I've seen it practically happen. Self-regulation has worked. ASCII is a great example for that. The digital platforms are sort of trying to do some form of self-regulation, which it is reaching somewhere. But I feel like there needs to be industry unity first. We can't have different clients having different views and expecting to be part of a self-regulatory body when they're contrary opinions. One recent example, there's an industry association that we work with. They came to us because the labor code has been passed. They asked us, how is this going to impact us? So we sort of gave them a presentation, told them that, take an example of, say, working hours. Working hours are now limited to 8 hours a day. Labor is now defined as anyone in the audiovisual industry. They are laborers. Our clients came and told us that this is not possible. A film shoot goes on from 12 to 16 to 18 hours. How is this going to work? So self-regulation needs to come with sort of industry backing and like cohesion amongst various players. Otherwise, I don't think it is a solution to anything.
If I can share an example, and I think we are a good set of people here, but we are 1/3 of the story, so to speak, okay? So I had an interesting experience just to share it. When Arun Jaitley was the law minister, he decided to form a committee to relook at the Specific Relief Act. The Specific Relief Act was primarily based upon damages first, specific relief as a backup. And that was not working with foreign investors coming in because we are putting money in for a project. We're not putting money in to get damages at some stage in the distant future. That was the primary objective. The committee was formed of a joint secretary, somebody from DSK Legal who knows policy drafting, Amit Kapoor from JSA, Akshay Chudasama from, at that time, wherever he was. No, he was out of JSA. He was in between AZB. There was me and there was a couple of other people. What was interesting was because of the way the discussions were with the so-called stakeholders. So Amit Kapoor had the infrastructure experience, which the other didn't have, etc. But the government position was actually very interesting because they kept on explaining why no change could ever happen. That was their mindset at that point of time. And we had literature, we spent, I think, 30 or 40 meetings, etc. What came out of it, interestingly, was, I thought, quite dramatic. One was that there should be a time frame to complete suits having any public infrastructure involved. And this came partly from the coastal road being, well, that time the sea link being delayed by so many years and the cost going up and it not being available. Second, we said that no court can grant an injunction against a public infrastructure project, which is to again delay things, etc. And specifically should be the norm and damage is the exception. Now, because there was a meeting of minds across various players with different stakes involved, I don't believe there's been a challenge to that till today, from 2018, which is 7 years, which is not bad, given every act otherwise and every rule is challenged like 100 times the next morning after it's passed. So maybe Abid Spilani or whoever it is who can, I don't think we can trigger it as a law firm, I would love to, but it may not be viewed appropriately. But an industry association, a university, a group of universities, if they can trigger a joint meeting, and meetings is not going to finish in a 2-hour session, I think this is a great start to put thoughts together and give a white paper. But if that can be done, I think the thinking evolves into a much more mature level and can be implemented possibly in a manner that can sustain.
No, absolutely. So, Zamir, do you want to quickly add on this? I have more questions.
Correct. So, good morning, everyone. So, 3 things I just want to add it based on our experience. I think one experience, Prashant and I were working with Balaji Telefilms, Ekta Kapoor also at that time we had done this exercise. So, I think self-regulation to an extent, bringing a law which is just a framework, completely agree with you, otherwise it messes the whole thing. And the industry consultation with consensus, all right? Because we saw this drama when the Copyright Act was amended in 2014 for giving royalty to singers, musicians, and lyricists. We are in 2024, it's still not implemented, right? Because there was industry consensus was not there, in principle. Second, I think on self-regulation, industry, it's very exciting also that, when you speak about self-regulation also, industry actually initially does not want it, all right? So in 2014, we were just on the verge of OTT being self-regulated. So we were working for Balaji Telefilms, Ekta Kapoor, and, we had drafted the self-regulation policy for the government also to make their presentations. But fortunately, unfortunately, the regulation did not come effect. We are sitting in 2025, right? So I think self-regulation to an extent, having a framework of law, industry consultation is the bottom line for me.
I think No. So I think just a few points to what everyone has said. I think just laws being on first principles and frameworks, I think as everyone has said, and I think that's the only way they will stand the test of time. Otherwise, with digital, they will be outdated before they're even kind of brought out. I think the other thing that perhaps we need to chat about a little bit, I don't think it applies necessarily to sports, which is what we're discussing here, but I think one of the challenges we also see is state subjects being, in that jurisdiction kind of, how does it work in the digital age? So either we have where no one wants to act, or then, I don't think we've had yet a situation where multiple states have said, no, we want to kind of take this issue up, but, we've kind of seen that as one of the challenge. And I think the other thing, I think, as you rightly said, is this whole, what we are calling co-regulation, which is self-regulation with a legal backstop, tends to become the most effective because, at the front end, you have something which is typically no cost to the government, no cost to the taxpayer, funded by the industry typically and pretty fast, agile. In our own experience, on print and TV, we have nearly a 98-99% voluntary compliance. On digital, it is still upwards of about 85%. So it's not bad at all. And for the rest, the government must step in. So I think that's how probably the framework, could be made more effective.
Oh, I have really nothing. Everyone's saying, and Manisha sitting next to me, I'm also on the CCC, so I'm completely on the self-regulation train. No, I have nothing different to add.
Just a little thing I would try to focus on is the commercial aspect of the viability of the content. So, me being on the content producer side, the normal issue which I face is the gap between the demands of the broadcaster and the celebrities. So, just an example. The broadcaster demands every rights by using AI, which the topmost celebrities don't agree. So, if at all, while framing the regulations which we are discussing here, there is a little consideration about the rights of the artists also. We cannot just ask anything from them. Like, we cannot dub their voice using the AI, which I face everywhere. Nobody is ready to give me this right, and the broadcaster doesn't give away with this. So, there has to be somebody who would be actually communicating the practical implications of the law while framing the acts. Because if I, being a celebrity, and I have to sign, or I have to convince my client that you give away your rights, that they can use your voice, they can tamper your images by using AI. First, I have to be convinced to convince my client, right? There is a very big issue coming up with this AI, and there is no regulation to it.
I mean, AI is the piece we go back into
Yes.
just immediately after this. I'm going to move to Girish there. I know, sorry, it's taken time to get to you.
I know, no, sorry, I was late and apologize for that. I come from I'm actually a misfit in this entire group because I come from the business side of things.
No, so in fact, to be very honest, that's why I need your views and I need Zamir to kind of add further to it, because you guys see this happening in terms of how it impacts you in reality, right? I mean, with due respect, I mean, a lot of the lawyers, we see it very differently, okay? I see your pain, because when I sit in the business, I know what is going on. It's nice to say law is there, unified, all of that. But when the guy pushes you and says, "Ye to mujhe chahiye hai," it becomes a different problem. So
No, so true. I was a lawyer in my past life, so I feel the pain on both sides, actually. I think when we look at the business side of things, business is about opportunities, right? And people are constantly looking for new opportunities. If there is an opportunity that arises, it is mandate for a person who's running the business to go and explore the opportunity. The conflict arises when there is no law or there is no legislation dealing with the new opportunity. And I think that is classically what is happening in the last decade, because the opportunities are getting so quick and business is running so fast, and legislation is always trying to catch up with that. I don't think we've ever faced these kind of challenges in decades before, because it was always perceived that once you have rules and regulations, legislation may need I would say updates every decade, if at such, and then that started getting lesser and lesser and lesser, which in itself is a challenge, like what Mr. Anand was just saying. How do we change it? And a great structure is to go about galvanizing opinion to be able to change the same. But what do you do when the business itself is trying to figure out what is the next opportunity, right? So I think we are currently at that phase, specifically in the media space. Because when we look at media, and whether it is audio, video, whichever of them, they've always been the forerunners, and technology has always disrupted that business, and therefore it has always been right in front. And then legislation starts catching up with it. So whether it was, we still have challenges with the copyright law. We still have challenges in terms of what happens when you create new content, how is it distributed. And there has been catch-ups that happen with law from time to time. But the minute the law catches up again, business has taken 5 steps ahead. So what do you do therefore? And therefore, debates about whether there should be self-regulation, because you guys are running the business, so you should regulate yourself. But the business opportunist will look at it and say that, why should I? I'm going to go out and do this because it's an opportunity for me. And classically that's happening with AI, because we are so now aware of it. We can make music without having anyone's permission. Should I do that or not is the question, when the Billboard #1 charting artist is an AI artist at this point in time, and the person is sitting down who's created that, minting a lot of money on the back of it. Will he self-regulate to say, I shouldn't do this? So do we bring morality into the question therefore? So self-regulation also is a lot about morals. It's not about some kind of law that gets put into place. I believe self-regulation in a business environment will not work because you're going to go after opportunity. You're not really going to wait out it. Whether law is going to be able to address that is a huge debate, because you will need to really sprint now as people who are drafting laws and also implementing it, and also in a way where it can be modified as quick as technology is developing. So not just trying to create a framework right now where we're saying, okay, this is now how it's going to work, but we need to start thinking like people who are agile, saying this will probably work for the next 6 to 12 months, and we will probably need to change it every 6 to 12. So how do we look at that framework in mind?
No, absolutely. And I think, I'm glad you stated this, because, I mean, like what you're saying and what Diva said, I have a very different view on exactly what you're saying, because at the end of the day, when you're sitting in business, you don't have time to self-regulate. And if you think you're going to put something in self-regulation, the fact is, forget, kind of the government or anybody else or the industry coming together. As a GC, you can't do it as fast as they do, yeah. Because the fact is, and I see this on a very everyday basis where, my founder will come and say, this is what we are going to do now. I'm like, hang on, this was something else yesterday, yeah. And I'm still thinking about that. So he's already kind of gone 2 steps ahead. And so therefore, you keep doing that, which means that you're not thinking of self-regulation. I think, bring a very important point, because I'm going to mix that a bit with, one is the morality piece, right? Because at the end of the day, absolutely we are here to do business. That is what it is. I mean, the aim of the business is to make money. I mean, there's no doubt on that. Nobody does business for charity. But at the same time, right? What responsibility do you have? More so given with the whole AI piece coming in, right? As you rightly said, the guy who's really chart busting is really AI. I mean, you look at everywhere and you look at Insta, you look at everything. Pretty much there's AI, right? So and sometimes very difficult to make out whether it's AI or it's actually, genuine. Which kind of makes us think, and I don't know the answer to that, but at least the way I look at it is that while self-regulation seems to be the thing people believe is an easier fix, but there are more complicated problems there, especially when it comes to business and kind of how you really deal with business and the issues and the morality part. And so to what extent will a self-regulation really be able to deal with some of those? I don't know the answer. ASCII is a great model, but I think it's evolved in the last 40 years. I don't think the whole ASCII model was perfect at the beginning, and you've seen your bit of problems. You still have those issues. I mean, gaming industry is a classic case where while, some people were agreeable to do certain things, but then there was a whole lot of rogue elements doing whatever they wanted, right? So going back to the point, when we come to...
just one bit. On the business aspect, I want to say some important thing. Agree to what you say, but it also depends in the entire industry. Where are you as a player? Are you a significant player or are you a fringe player? I was always in-house working as GCs. Now moving to other side where I primarily advise mid and small cap companies or startups. They see as a survival game, you are a fringe player versus a key stakeholder. Who is sensitizing the issue in the industry makes a lot of difference. So in a classic example, whether it's a CDMA versus GSM battle that happened, or it's a studio versus authors battle, it all depends who is driving the proposition, number one. And for the fringe players, it's more a survival issue. For them, I like to say, today the issue is burning, let me execute the deal and move forward. Or for a deal when you're doing, it depends that rights will fight when it comes later on. So how good as players in industry, you are building an industry per se, making a valid ecosystem rather than one mega behemoth coming and making the 80% stake and spoiling the platter. I think that will also have an important role on how a self-regulation versus things will perspectivify. I think that's one aspect has not been, we have to keep that in mind.
Absolutely. And I think, this is a topic itself which can take like hours, but I'll just, and I want to move because I know
just
Zamir
want
wants
to add, the insight, very practical perspective, first thing, insight that I've had is, it's better to be regulated by your peers than by government who has no skin in the game. So it's better to work along with your peer because you don't want to be regulated by somebody who has no sense, no business, connection with it. So that's my learning has been, and I thought
we missed you, right? Sorry, did we miss you?
The only, sorry.
stepped out for some urgent.
Okay, I'm sorry then.
So, see, everybody is actually given their piece. Hi, I'm Nadia. I'm an associate partner at MZM Legal. All that I want to say is when you have self-regulation versus a regulatory framework, as Girish rightly mentions, when moral rights step in, there is a clear conflict of interest. Business wants to do business, right? Business does not want to make laws. So that's the job of the government. And the government needs to really step up and evolve with the evolving times. So I feel that when it comes to moral rights versus you being self-regulated, there will always be a conflict of interest, and the business will always choose business over being the regulation. So that's
But I think the point, sorry. Yeah, go ahead.
I think one of the things that we need to think about is self-regulation really about morals? And I mean, we should really stay far away from that point. I mean, self-regulation has nothing to do with morals. It is set up in the industry's self-interest. If you don't have consumers who can trust your brands, who can trust your practices, then you have no business in the long term. So I think we need to move away from this notion or this mental model that self-regulation is about doing good for other people. It is a hard-nosed business decision that is taken collectively. So that's the only difference, that as an industry you're doing it versus are you doing it collectively. But it is fundamentally to build trust, and without trust, what kind of business would you have in the long term? So to me, I think the way you were saying that, what is your player status in the industry? And to me, anyone who is in it for the long term, will kind of believe in, or will kind of contribute or be open to self-regulation. Because as you rightly said, I mean, you would rather have a set of rules that make sense to you and have been developed by the industry than coming from the outside.
And the most important aspect from an aspect perspective, the major players accepted hard decisions, implemented them to validate the self-regulation. I think that plays an important role for the self-regulated regime to survive.
See, I think it also depends which part of the industry you're in, right? So I think there are several factors. I completely take your point, Manisha, but I think it's also got to do with the fact that even when you were talking about it, Mohit, are you the dominant or are you the small player? The fact is the way the tech moves, you may be a dominant, but a small player can come and beat you very quickly. Before you realize you're way back, and then there's a small player who's done something completely radical, thereby making you insignificant. So I think, gone are those days where it was about size and scale. It's about speed and ability more than size and scale, in my view, and how you kind of are able to do something which is quicker, which is what the world wants. I mean, that's how the business looks at it. But having said that, I just want to move, and we were just talking about the AI part. I just want to come back to the point about if you look at, kind of from then let's look at the media companies, let's look at the digital, sports companies, anybody, for example, AI is coming big, right? Now, AI has its own challenges because, as usual, and I'm saying this on the record, the fact is that, I've been hearing the government saying we're looking at AI regulations. I mean, nothing's happening, right? At a particular conference, some of the senior most government officials said, we are forming a committee. I have not seen that committee ever come up, right? I was asked one day, who do you think it should be? What kind of people? And then, kind of, will you be a part of it? Yes, that was all exactly about 16 months ago. 16 months out of that, nothing. Having said that, kind of especially with this whole AI-driven growth, the IP, the privacy, the regulatory risk, and I think I want to stick to the policy part. So again, what policy reforms can there be? Now again, self-regulation is one part, but I think these are things which need beyond self-regulation, their policies, etc. So how do you see that, and how do these companies keep an advantage globally? Because the reality is the boundaries are no longer existing, right? I was talking to somebody yesterday. Look at the legal services, right? Look at what's happening in, whether you look at a spot draft or you look at an ironclad and look at some of the other. It's just going, kind of the way technology is developing, you can do stuff that lawyers did, took like 3 days, you do it in like 30 minutes, right? And that's the same thing's happening globally. So how do you kind of manage all of that to keep the advantage, or are you going to lose out of the global advantage? Maybe I'll start with Zamir here.
For us, as an industry in VFX, animation and production, so I work for a company, DNEG, Double Negative, internationally known. It's an 8 Oscar award winning company. Angry Birds, for example, is one of their products. etc. In India, it's known as prime focus. So you see Bahubali and the Ramayana film which is coming, the VFX and all the effects has been given by the company. So next time when you see Tom Cruise jumping from the bike and then it is connected to the train, that's your VFX, right? Now we see in terms of numbers, what's happening on the IP privacy side. Like my friend was talking about the consent of an actor for voice. Today, if I take a voice of yours for 5 minutes in AI, I can use that for dubbing my whole movie, right? There are technologies which are being developed where AI is brought into light in a positive way in deepfakes, where I can have a movie of Shah Rukh Khan today, but I can show him as he was looking in Dilwale Dulhaniya Le Jayenge without even making a single point difference in that particular effect, right? So I can have the same deepfakes positively used. That's the kind of technology. Now we see everything in terms of numbers, right? Globally operated company. So what's the trend globally? What's the trend in India? And what's the issue and challenges in terms of numbers we are getting? And that's how we strategize our move and how do we safeguard ourselves legally, right? So I'll just cite some numbers to you. Now globally, the global media and entertainment industry has crossed about 2.8 trillion, right? We are living in 5 trillion economy in India. The global sports industry generates about 600 billion US dollars, driven by media rights and sponsorship. Streaming platforms now account for 65% of the global video consumption. Digital advertising represents more than 70% of the total global advertising spend. User-generated content platforms drive over 50% of global digital engagement. That's the voluminous numbers we are talking about globally, which is happening. Let's talk about India. The India media industry has exceeded about 2.5 lakh crore as a spend in the sector. It's growing about 10 to 12% CAGR. India has about 900 plus million internet users, the largest digital consumer base globally. OTT platforms in India have already crossed 500 million active users. Sports broadcasting contributes over 40% of Indian television advertising revenues. India produces, of course, more than 2,000 films, which is the highest in the world. Digital advertising spend in India has now exceeded about 70,000 crores a year, right? Influencer marketing, which we all see on social media, is growing at the rate of 25% CAGR, which means in 4 years it will double up. That's the influence which is happening, right? These are the numbers in terms of business. Now what's the issue and challenges we are facing? Over 70%, this is the India situation, over 70% of digital content creators in India lack formal intellectual property protection, which means the content which they are producing or the content which they are publishing are not IP protected. Content takedown request has increased by about 55% after enforcement of IT rules. Media companies face multiple overlapping compliances at central and state level. I think somebody was talking about central state compliances, right? Sports piracy is about 10,000 crores annually in India. Fewer than 15% of digital platforms have mature compliances and governance work. Advertising and consumer law violations are exposing the companies to about 500 crore penalties annually. Contractual disputes around media and sports litigation have increased by 40%. Data privacy and compliance risk has significantly has increased because of your data privacy law now into being effect. Ownership and liability for AI generated content remains unclear in about 60% of the cases, right? So that's the numbers we are talking about. Now, when you have these global numbers, India numbers, and the issue and challenges numbers, we are increasingly seeing that, companies which are looking out for consent, right? What was the original policy when internet came? So every website and app you will find these 4 things, right? Terms and conditions, how to use the website. If you don't agree, don't use it. Then you had privacy policy. I can sell out your information to any marketing company, all right? That's how Facebook, Cambridge Analytica, we all remember. Then it was cookie policy, right? So cookies which you're using, I can identify your geolocation, whether you're sitting in Mumbai, Bandra, Delhi, etc. And then copyright notice, right? Where if something is infringing, please write to me, I will take down that. What we are now seeing is that mostly the issues are coming at the consent level, at the intellectual property rights level, and at the AI generated content level, where whenever we are embedding that to any content, the certainty of there being not a claim in next 2 years is the question mark. So we've figured out this 4 policy in our company, because we also deal with Hollywood studio, and if there is any IP infringement claim for a Tom Cruise movie, you will have a bankruptcy proceedings, right? So what we did is that we took one step where whatever AI we are using, we are putting an annexure in our agreement saying that this is a good faith disclosure. So whenever we are signing with any Hollywood studios, we are putting an annexure saying that I'm using AI technology, this is my good faith disclosure, because this will help me in my mitigation, right, of my liabilities. Second, there's a huge negotiation which happens on the limitation of liability clause, because nobody wants to limit your liability because you're a service provider. Third, on the intellectual property, good faith disclosures are made. Fourth, we are now insisting that any movie where we are using AI, this has AI insurance, which is a new concept, probably will also land up in India very soon. So these are 4 mitigation effects we have taken from a business standpoint, so that in case there is an infringement of IP, or in case there is a claim against use of AI, etc., contractually and in terms of my liability and in terms of my insurance, I'm well protected in my business. That's my point. Thank you.
So, I mean, that kind of just takes me to another point, and I want to, in this, more get a little bit of business perspective as well, especially with the use of the AI and the way the AI is coming, we see deep fakes, we see some of all of these issues, right? And increasingly, I think every company is saying we have to use AI, and AI is kind of obviously the way to go going forward. I mean, I hear this every day saying, and I think, kind of, sorry I say this, but I hate it. Every time, chat GPT is saying this, yeah. I don't know what it means, but in the sense whether it's going to be right, wrong, I don't know. I mean, it's pretty much accurate to a large extent. Having said that, I hate to admit it, but that's really where it is. So from a business standpoint, right, and especially if you look at it from the perspective how AI is going to be turning around and, kind of be an integral part, right? And the fact that, kind of the law is, of course, still archaic. You talked about the part about, morality or etc. For a minute, I'll park that aside. But in terms of business, etc., how do you see that developing? How do you see protection issues there? Because the same thing that I want to ask from a legal perspective, saying, kind of where do you then see it from the other side? One is a business perspective, the other is a legal perspective. And then, Manisha, I need you to come in because of the whole, how you're seeing it from an advertising, brand protection, brand perspective, because it does have an impact in terms of the whole brand and the advertising piece.
Thanks for that. I think anybody who's looking at it from a business opportune perspective and predicting what AI is going to change in the next 5 years, my personal view is they are probably wrong. Because the people who are developing the technologies themselves are so unsure about what is going to happen in the next 2 to 3 years, let alone the next decade, that its impact on various businesses, including media and across the board, like you were pointing out, legal as well, is currently a complete blind sight. The only thing that can be done is that we are constantly trying to figure out where the technology is going to go in the next year, and then see how everything aligns behind that. That is what my view is. I think what is important in that scheme of things is that what is our relevance to business and how is that going to evolve, and is that got a space behind where AI is developing, I think is a core question for a lot of businesses to ask nowadays. And we're finding a lot of businesses asking themselves that question, are we even going to be relevant in 3 years from now, especially in the media space? And there is 100% trickle down going to happen to other businesses. I kind of see it from a perspective of, if we look back to any big technology that has disrupted industry, whether it be the invention of, whether it was the printing press, whether it was digital technology from cassettes to CDs, whether it was computers and typewriters going out. I mean, how many people have stenographers in their office still, and shorthand? We know, we heard of them, right? And we've actually interacted with them. But they are not relevant anymore. So they've obviously gone and figured something else out. But that line of business has stopped completely, and it's evolved to something else. I sometimes feel we are that generation that is going to go through that. And we can either be rigid and be like, no, that's definitely not going to affect us. It's not going to happen. And then suddenly we're going to find ourselves irrelevant, and technology has changed everything around it. So I don't have an answer to your question to be able to put it out there saying this is what's going to happen, because I believe that's going to change from a year from now, whatever we talk about, and that's again going to change. So the only definite constant is that it's going to change. Whatever is happening now is definitely going to change and be disrupted in a big way. So we need to constantly be looking at as to which direction that's going to go and how that's going to impact our industry or businesses specifically.
Just one follow-up question, nothing to do with this, and I can completely what you're saying, just is my own this thing. So as when you're sitting in the business as the person, kind of really deciding it there. I mean, earlier if you see technology or anything that lasted, there was a time period. Things lasted for 20 years, 10, 5, whatever. What do you see future as? In the sense that, is it like days, is it weeks, it'll be a few months? What do you see that happening?
So till AGI comes about, which is artificial general intelligence, is what is something there's a race to the bottom right now for that. Till that comes about, I think we've got 3 years to 5 years. Once AGI comes in, you've got a 2-year cycle probably. I mean, the guys who are working on AI are saying that everything is going to change before 2030. That's like an outer limit, right? I mean, we're literally, that's 5 years away from now. And the minute AGI comes in post 2030, if it comes in between, I mean, the latest is 2032. And once AGI comes in, then it's a 2-year cycle everywhere. So from the position of where I am sitting, I'm very aware of the fact that technology is going to disrupt the businesses that I am sitting in. And therefore, for example, there was a conversation and a point about influencer marketing campaigns, right? Digital content. Now, digital content is seen, it's currently at 25. In the earlier years, it was seeing anywhere between 25 to 40% CAG. And now it's kind of justified itself between 25 and 30 odd. So I think over there, what's going to happen is that we'll see a constant uptake till the format will change. So then you're not going to do a terrestrial TV anymore. Yeah. It's already on the downturn. I mean, India is a debate because India has still got TV connections more, but they've got more mobile connections, but they still have lesser credit card connections. So it really, I mean, you have to triangulate information constantly to try and figure out where is business opportunity going to arise. And I think at this point, digital technology will stay for the next 5. It'll continue to evolve. The servicing platforms will change. So whether it's going to be, television to mobile, or mobile will evolve into something else, I think that is not, because that requires hardware as well, and not just digital. So hardware will stay out the longest till adoption happens. But if there is a higher rate of adoption when it comes to content consumption or platforms, then you're seeing a kind of a decade period. But if adoption happens in the way that it has happened in the last 5, I mean, all thanks to COVID, if we have another event, something like that, and we suddenly start adopting a new platform or new formats of consumption of technology or content, then you're looking at, I mean, a decade is like literally what we used to, back in the day, would say, you know, that's an era in that sense. 10 years is a long period of time.
Samir, I just wanted to add,
Sorry, I just wanted to.
No, fair. So, I mean, from a legal perspective, I think government is, is being a little watchful, is how I look at it. They are not rushing into it, which is, a right approach. Of course, they are having those think tanks. They are coming up with white papers, for example, on copyright and AI, the intersection part of it. There was something which came from recently on deep fake, intermediary guidelines. So they have been opening up. They are, mindful and how sort of a thing. But rightly so, they are not really, pressing the pedal here, and which shouldn't be the case. Not AGI, somehow I heard on, one of the podcasts on the Ken, they said some reason because of the current LLM, the tech that space they have, seemingly AGI is a little more far. Which is in a one way good news, I would say, to the human mankind. And so, yeah. And I think, one of the hotly, kind of issue which is being looked at currently is AI and the, intersection with copyright. How and what, data text mining, whether, the generative part of AI, should they be a copyright, who owns it, and all that kind of thing, I think, yeah. That would be probably meaningful if, to talk about.
Anybody else has a...
I think on the aspect of Girish, I think the most important thing is what is the monetization that can be possible given that Indian market is very price sensitive. People are not willing to pay if it's free. You see the Jio's Hotstar, when it came as free was all the content if it is willing, and as you went across, the cost is so high, the content monetization. Secondly, when you say a new disruptive technology comes, there is a huge I think cost to investment. And from there to monetize, if the timelines are getting squeezed, I think it's going to be a difficult scenario for any business to look at the opportunity also. India is a very, very price sensitive, we have seen in all things. I think that makes me even shocking when you say that the time horizon is getting further shortened. It will going to be very difficult for the CFOs and the business analysts to look at how to monetize it in the short run. On that opportunity, one more aspect which I want to say is the current AI governance, the guidelines, which came in November, at least to now say that there won't be a special law for AI as of now. They're going to work with the existing laws. They are looking at the IT Act, the DPDP Act, the BNS, which replaces the IPC, and looking at even the Consumer Protection Act to look at it. That's a first. Second important thing which I believe is intermediary role needs to, we look at a redefined. I think currently we already seen, in my perspective, the Shreya Singhal last one paragraph changed the way we looked at intermediaries and it moved on. And recently the Karnataka High Court in that Twitter matter has come with, on the Sahyog portal, has come with a revised detailed judgment on that. Yeah. So I think judicial precedent on how it will happen on the intermediate front is one important thing, because lot of monetization happens with the existence. And I think one aspect you may touch later is the personality rights, where currently we see lot of judicial precedents happening from a complete law which says that everything's protected to last week where the Delhi High Court said that I will not give you something, you go to the intermediary. So I think one framework which I would like to see from a legal perspective is how the role of intermediaries is going to be defined, and whether they're going to be hit by regulation is one. Number two aspect, I believe this, the role that comes is safe harbor. I think that has evolved over the period of time. So I think those things, keeping in mind, because every time a business puts a notion, they want to see the defense first. And as in-house legal or even advisors, we see how to protect the interest from any, any adverse orders coming which can penalize you or do something. That is something. And the last piece would be whether the DPDP Act implementation on AI with the huge penalties would impact. The only good thing I see from a DPDP is the time to implement. For the first time in India, I've seen you have got very good horizon gestation period to implement. Usually you see a GST Act coming overnight, changes of law happening. One of the good things I see is you have a timeline to think and decide. So I think a lot of good things to do which you can work out. But I believe, as always said, and what even our colleague said, industry needs to take the first lead. It cannot be possible. It has to start with industry.
Sorry, I think Zamir, you want to head out.
I'll take the lead. Thank you.
Okay. Thank you. Yeah. Sorry, you
Yeah, just to respond to that, in fact, because there is so much vagueness about the implementation of the laws, forget implementation, the creation of the laws, and therefore the implementation, I think currently the interpretation is currently going to be the only way that you are able to sort this. And to all of the students in the room that are going to be lawyers, I think this is the best time for you, because you will be able to interpret it in ways that people currently do not even have visibility on. So understanding what current position is and therefore doing interpretation, it's like everybody is going to have a constitution in their hand and you can go anywhere with it. So it's going to be quite creative in terms of judgments, etc., that come up till legislation catches up.
Again, sorry, just one point. Again, when we talk of AI, normally people like us would think of digital avatars or voice cloning, etc. Yeah. And I think, which culminates into personality rights. The courts have dealt with personality rights on a case-to-case basis. And what Girish has rightly pointed out, that it's all about interpretation of judicial precedents. But I think there has to be a clear law, because as many people interpreting judicial precedents, they would turn out to be different laws for that. So I think the parliament needs to step up and accelerate the manner in which I know it's difficult to catch up with the growth of AI, but I think there has to be a beginning and not just rely on the old archaical laws like the Consumer Protection or the IT Act, etc., etc. I think that is much required rather than just relying on judicial precedents over here.
I mean, my personal view on judicial precedents, nothing's happening there. I mean, this is just data, more relevant for the lawyers. 7 Chief Justice in a row, whose first statement was, I have to solve the pendency. 6 did nothing, the 7's doing nothing either. So I don't even want to go down that path, because no matter what you do, it will never happen. One simple example I'll give you. Supreme Court of US and the highest court in the UK, they take an average of between 20 to 25 matters in a year. One single court or bench in India takes 127 matters a day. I mean, we need probably half the population to turn into judges to solve that. But that's a different, and maybe I'm going to ask the British Law School, that's another round table, huh? You can do this.
So
I mean,
between Nadia and I, we appear in courts on a daily basis.
Yeah.
And there are judges who are enthusiastic and who even sit after court hours. But still, I mean, hearing 100 matters in a day, reading of how is it possible, and making judicial decisions on that, which has an impact on the litigants and their families, their lives, their businesses. I mean, just one small mistake of a judge understanding a matter in that few fraction of second, and nowadays we call it as an ad interim justice. Honestly, you file a suit, you file an ad interim application, you get an ad interim relief, and that's it, because your case is going to get finally decided after 20, 25 years. So that's ad interim justice that that era that we are living in.
True.
So I think one of the important reasons why litigation is very high in India, as you rightly said, it's a different paper in itself. I believe that India don't have a precedent for compensation or liquidated damages as an evolved from a judicial, because what happens is it's a luxury to initiate a litigation today and keep it pending so that you get interim benefits. I think it's so easy today for a person with deep pockets to just initiate litigation and appeal.
That's a different can of worms.
So
I won't go down that path. I won't go down that path. If you want to add something, I want to come to Manisha.
No, so just on the AI bit of it, see, AI is not only disrupting media, it's disrupting how you see everything today. From legal tech to how you translate money now on the crypto front, right? There is so much, and it's so deep that the government also does not know at the moment whether they are on the side of AI or they are against AI, right? And sooner or later, I think a regulatory framework will come, because AI has its own boons and has its own cons, right? So we will have to, it's a wait and watch game at the moment to see how disruptive AI is for the businesses. But from a lawyer's perspective, more the ambiguity, more the billing hours, and more the work we have, right? So we have to fill in the gaps, and we have to give in more hours for interpretation that businesses can't do on their own. So.
I'm going to, Manisha,
I've been wanting to say some. I've been actually quiet and just listening to everyone, but I'm going to beg your pardon if this is any kind of overreach. But I'm trying to sort of align all the thoughts that seem to be going around the table with the larger objective that the idea is to convert whatever we are discussing into a white paper. And I find myself a bit lost in the number of strands that we are hearing today. And therefore, with a little bit of your permission, I want to just encapsulate all the things that I seem to be hearing here. And Manisha would probably be grinning because I end up doing this all the time. It seems like we have this huge commercial and economic contribution of the media and entertainment world, which is being right now completely boggling us with the advent of AI and the fragmented legislations, the collapsing of time that Girish spoke about in terms of compliance and new opportunities and things like that. And when we are looking at having a discussion and having actual sort of recommendations that we can put into a white paper to give whoever it is, the regulator or the government, what is it that we all spoke about? I think there was a faction that said self-regulation is great. I'm part of that faction. Self-regulation with Mohit as well, self-regulation with a legislative backstop. Self-regulation is good, but it needs to be guided by judicial precedents. Judicial precedents is a bit of a waste. And aligning all the stakeholders within the, I think that's a useful point that we may want to deliberate on in terms of how do we align stakeholders within the ecosystem. One way probably is to get the legislative backstop and to get the judicial sort of the guiding principles rather. So maybe and personality rights, how do we really write that into the law? I think we are all agreed that there is no one umbrella jurisdiction, but how do we write that into the law if we can sort of dig into that and then... I'm sorry.
No, perfect. I have to say, this is like the Salman Khan or Shah Rukh Khan moment to come and just say, because, let me just state right here. So I think, thank you for that. That really helps because once Manisha says what she has to, I want to move into the sports side because I got accused at one point of time saying it's only sports and I realized it's only media.
Yeah, so I think the view that we are forming in general on AI and its use in advertising, this is a consensus which we are trying to also build with several other ASCIIs of the world, so our counterparts in other countries. I think the idea is that we are not perhaps very keen to regulate the technology itself, and therefore we go back to first principles and saying what is the consumer outcome in this case, right? So has that AI resulted in the consumer being misled or the consumer being harmed? And therefore what is the governing kind of principles for that, which, I mean, in a way I agree with the government, all the laws are in place. I mean, maybe they need to be updated and, all of that, but, there is a Consumer Protection Act which says that, ads cannot be misleading. And I always say that whether an ad is made by AI or whether it is hand-drawn, it can be misleading irrespective. I think the AI challenge is just that it will be done at a scale, which is perhaps almost impossible to monitor. It will be done, let's say, the intersection of AI and dark patterns, will come in where it becomes extremely difficult to even have technologies to kind of monitor that. And then what do you do when you suddenly have 1 million data points which are, let's say, violating? So I think it is, so to me the challenge is not so much the regulation of the technology, but really how do we kind of manage systemically, the vast amount of information that AI is now going to throw at us. And, so I think we will keep going back to first principles and all of that to kind of sort out our lives. So, yeah.
I just want to take, another 30 seconds on this point. I mean, one is, Manisha, just to add, on piracy side, on how media, is able to take care, and as you rightly said, it runs into millions, of such content. How do you ingest, you as an IP owner, your property in a, say YouTube or a Facebook sort of a thing, and which itself takes care of, it brings down, the copyright strike is there, and so those contents are taken down. So essentially, similarly, on AI side, there would be, just going back to the personality right issue, I think it's not about the law so much. The real issue is with the intermediaries, because law protects them to that extent that they are not willing to take down anything unless there's a court order. So because of the court order, and that happens on media rights as well. We have Copyright Act, right, which protects it. But you need to go to a court whenever new movies is being launched, any big budget or, sports game, rights are there. People have to move to court because of these intermediaries. They will take down the content basis, a court order. So I think that is where the issue is, and that's the reason the government came recently with deepfakes, essentially, putting the burden on the intermediaries to say, well, you should have the tech in space, to ensure that such, material is authenticated, is well aware who is putting it, and, so the steps can be taken. So I think that is the gap which needs to be filled in, rather than, looking at law from that perspective, to my understanding. Thank you.
I think when we are looking at this white paper, we have to look it from a stakeholder's perspective also. Yeah. One side is the business, second side is the consumer, third is the regulator or the government, whether they want to have an active role, and last would be those multiple other stakeholders in the chain, whether the fintech players who are going to make the money, who are going to collect the money. I think we have to look the perspective from the huge entire landscape. That's one perspective.
Yeah, no, absolutely. I think we will put pieces of that together. But just as on this part, at least, concluding, I think the way I hear everybody, my sense is that obviously there's no one regulation and there's no one solution that fits all. But clearly, at least what comes out to me as a theme is that you got to regulate the right spots. It's not about just getting a regulation, and I think that's where it is. For example, an intermediary is a classic case. You have to hit it at the point where you can solve it rather than, saying I'll get a law and then I'll figure out how the law gets implemented. So I think gone is that era when you turned around and got a law which was a nicely written act, and then you got some rules, and then you just kind of said, chalo, implement karo. Because it is no one size fits all. The technology moves faster than you can think. Everything has changed so much that eventually you will have to kind of, it's going to be horses for courses. Yeah, that's exactly what the thing is. And I think the only piece I would say is it's for the government to really step up and speed up all of that to say, pick the right spot, regulate it, or at least put guidelines and let them go with it. The courts, on the other hand, absolutely need to step up and say if there are disputes, then how do you really solve them quickly, thinking commercially, yet thinking, from a society at large. But the one thing I definitely don't want courts to do is to then become the moral police to decide what is right for them is right for the world, right? You got to look at it from a society at large. So having said that, I think, we spent a lot more time on this than I'd initially thought, but thank you for this. And so I'm going to move into the... That's true. Except that what I wrote wasn't written by AI. I kind of myself wrote all of this. And so no, so basically, it's this classic case, AI coming and disrupting what was written here, right? But moving on to the sports side, really. I mean, I think a bit of this thing is going to be really sports and how it's kind of getting broadcasted as well as, kind of how it's getting taken. I mean, obviously the law has changed, and, we went from really, technically for physical sports, we still don't really have a law except the new national sports policy that's come, but that's more aimed at developing sports or growing sports. There are so many other issues within the sports piece of, there are sporting events, how do they get broadcasted, who has the rights, who turns around and then is able to, turn around and monetize it. Then there is also the fact that, within that also, I saw what happened when Messi came here, right? That's another classic case. Have we kind of gone now beyond to a point where these are areas which we never thought of, but they do have a law and order problem. They do have, so where does the burden lie, right? And therefore, kind of when you come to really, sorry, where is that here? Yeah, when it comes to really, kind of a mix between sports and OTT, what can be broadcasted, what can't be, has there been now, kind of, where does it really get governed and how does it get governed? I know it's a bit confusing, but it was to me as well. Is the fact that there's sports, there's esports, there's broadcasting of those sports, There's then the whole content and the fact that how do you regulate or how do you make sure the right thing is being done, and there are responsibilities. A bit of complex this thing, but just go around again to from the perspective of how you see it, or is it that no, it's not that complicated, you can just simplify it. We start, Girish, you have a thought here?
Structurally, I don't have a thought on this, to be very honest. It's not something that I've delved into. From, I think, a monetization or some amount of, I would say, commercialization, yes. I think it's very similar to the restrictions that are there on content in terms of how they get monetized, so whether it's broadcast. I would still say most of it is commercial conversations in terms of negotiations rather than regulation. Because most of the regulation from what I see is all government body in terms of, you know, who will basically decide rules around it and how commercial, the minute it becomes a commercial conversation, there is something to be said from a government body perspective. But other than that, I think the way, I mean, I've done some transactions where we've done licensing, etc., for big sporting events. Most of those are commercially governed by negotiation. There's no real restriction on that. So your IP laws that would be relevant for what you do with any format of visual content would also apply over here. All of the sports athletes per se, very similar to, you know, I would say talent, which is across the board. So there's again, their IP protection. I think debates now are happening around the fact as to, you know, when a franchise owns the particular likeness. Again, it's commercially kind of governed currently, but at some point there will be conflict because likeness of individuals also move beyond franchises. So there are instances coming up where franchises are not allowing for likeness to be exploited outside, you know, of that, etc. So again, a lot of this is commercially based, so it would be governed by most of the regulations that are already in place. There's no real evolution happening. I think with leagues, obviously that is a new area, that's a new phenomenon, and the government already has in place, you know, how you can form a league, how it should kind of run, etc., etc. Private leagues are something that are becoming humongous nowadays, which are not really throwing any governance over themselves till they become large enough for somebody to notice. So whether it is a Panja league or whether it is, you know, Kabaddi league, etc., they are at some level mandated to, you know, associate with already existing leagues under government regulation. So I think structures of most of those are already in place. It's not something that is kind of, you know, a wild, wild west kind of area. Commercial conversations, contracts, the evolution of management, there's a lot of movement happening in that side of the business. Again, because we are seeing sports as becoming, I mean, cricket was, I mean, it's cricket, Bollywood, and religion in India, right? The three things that govern everything. And that is slowly evolving from it, moving from cricket to, I mean, football has become huge, and rightly, like you said, you know, Messi coming over here and some messes happening on the back of that as well. But it's also evolving to esports in a big way, which I'm sure we'd love to hear more from you about that. Because regulation there also is something which is highly debated, and because it's not restricted to the territory, and therefore I think a lot of broadcast coming into the country is also a question. So there may be some evolution that is required. But other than that, I think from a commercial point of view, it's kind of most of the governances that are need to be in place from that perspective are there. It's just evolving in that area.
Okay. Do you want to?
Me being basically from the media industry, I'm not too much into sports, but yes, I would, you know, again say the same thing which I say that, you know, it has to be a balance between the business and the legal side, but not more into sports, so I'll not be the right person to comment on it.
Do you have a view on the broadcasting side for that or no?
No, I am hardcore into content production, broadcaster for media.
Okay, all right. I don't know. Nisha, you have a thought around
Yeah, I mean, I would again say that it is by and large, I mean, other than again the new evolving formats, etc., I kind of always go back to the first principles, which I think are well established in this case. I think an interesting aspect that, we discovered a few years ago in the Olympics was just brands congratulating athletes that had won, and, that could not be done. I mean, it's been done forever, right? I mean, no one really had a problem until very recently where, the Olympic logo couldn't be used, etc. So I think maybe those are the newer kind of realizations, or that's just the evolution and maturity of the market. But I think between commercialization and the question really, I guess, goes back to who owns sports. So there is, of course, the whole commercial aspect of it, but, it's also a national resource, or it's a national, I mean, just like how you have schools or whatever, I mean, you think of education. I mean, I think sports really also falls into that kind of an arena. It is part of nation building. It is part of all of that. So eventually, so that's not to say whether it should be privatized or commercialized or not. But I think, in what way is it done, which makes it available, for citizens and for a wider set of people to kind of come in and benefit from that, I think would be the only, question that I have in my mind. But yeah, again, it's not an area of specialization for us, so don't have too much to add to that. Yeah.
I think one of the important things is how has sports become an industry? I think that's a starting point for me. Cricket it's being, I think as he rightly said, it's a religion, so it starts with that. The amount of money that has flown in, take IPL as an example. Actually speaking, it started with Z starting the league, which didn't fructify and went into IPL taking that opportunity. The first of all is, how do you see that industry per se? How is, and anything in India, it depends on the monetization capacity. If the industry is big, there are stakes, and then you try to protect the stakes. So the starting point is, today, if you ask me, sports, in my sense, is 95% cricket only. So hence, it revolves around that. Certain pieces are being brought across, it will come over there. Once it starts, you try to protect the turf, and then the relation starts. Over the years, you have seen three big aspects happening in the sports area. Yes. Number one is protection of basic your exploitation rights. Number two is sports federation, elections and bylaws. That is one aspect. And lastly is how are the player rights being controlled and the franchisee valuation going up? So the issues around that. So we have seen 3 points to that, you may say. But the starting point would be to see how big is that sport, even to say Kabaddi. It started, it's growing up, the franchise are built up, pickleball is stating up, it's going to become the next big thing. So I think things evolve once there is a value to it. How the players come, if you bringing big players and franchisees, the IPL franchisee has now gone worldwide. The same teams, Mumbai Indians, CSKs are in the other parts of the world. So developing that IPR, making that monetization, seeing it from the first instance, I think you have to start as in-house or as advisors. We have to see that where does the money lie to how to protect start from day one. It's very difficult at the end of the day after 5 years to say that we didn't have these rights. So I think that would be the starting point for me. And lastly, it has to evolve with a balanced view between, say, a franchisee versus the players and the sports body. I think all three have important role to play, and I believe gaming laws won't be important. If you look at the physical side of it, it will be amount to only these stakeholders having a balanced view. When we come to e-gaming, right, and I see a huge potential there. Yeah, so it's going to be a big thing, and I think there we may require a bit of things to come out, where I think we will have maybe have a different point of view over there. We will get back on that. But e-gaming is a different ball game.
I want to move, and after
yeah, please, after that we
we'll be here.
So, sports law in India is largely unregulated. You know, there's quite a miss until 2025 that the legislation has woken up to get in the NSP, to get in the NSGA, and now
there was a policy from 2021 also.
Yeah, but it didn't cover all the aspects which now the NSP and the NSGA are looking to cover, and of course the Online Gaming Act, which has now come in, banning real money games, which we discussed earlier. What I think is a miss yet is nobody focuses on athlete rights, and what rights the athletes have in terms of their entire personality, whether it's with respect to picking up a clip in terms of a goal that Ronaldo has sort of, and then it's getting replicated worldwide. People are making money out of it. So athlete rights is something which is still a miss, right? But of course, the NSGA at least tries to bring in certain governance factors, which also, the leagues and the organizers who sort of now run self-regulations and bylaw models will have to have some kind of governance bodies which will take up various ethical and conduct issues in conducting the sport. So I feel that there's a welcome move of getting these 2-3 regulations, which sort of structure the sports law today in India and give us a picture of bright governance so that something like a Messi that has happened, does not happen again. And foreigners actually come here, build trust in India, and see that India is not largely a cricket, fantasy where 90% of the sports is only driven to cricket. We have a lot of talent, and in fact, our firm is helping set up a new league which is coming up, and that will be launched in Jan. And with these regulations now, we have some structure of how even the model should go down to the franchisees, to the teams, who are all going to be a part of the league, where they can look up to certain things which these governance rules will now bring in. So.
No, absolutely. That's a very fair point.
So on one point, when you look at the legal framework, the IT rules regulate the platform, and the sports governance is largely regulated by the NSG. And I think they both work in silos, and it's time that they come together and work as one agency. So that's one point I just wanted to bring in. Hopefully.
Which is, I think, a separate discussion.
No, in fact, that's the piece I want to go down on, saying that because if you look at it and, you have the esports, you have now the broadcasting bill, which is trying to look at something, you have, the NSP that's come in. How does all of this really fit in, and what is it that we really need? Because all of this in fragment is not going to work. That's the reality. And then I think, kind of, no matter what happens, and we haven't learned our lessons from some of the other places also. Like media is a classic case, right? We had all that fragmented piece where we've now slowly started to worry. Technology is taken off. We are still sitting there trying to figure out the fragmented pieces. Like we're still sitting with shattered glass and trying to figure out. This is a classic area where things are now beginning to happen even more, and therefore, what do we need to do here? And that's the piece I would want to really, kind of spend. And I know I'm also conscious of time. Till what time do we need to? So can we spend the next 15 minutes on this piece? And I think that's where it'll come out as a point which will be what can be recommended per se.
Sorry, I just want to move back just a 30-second point on that. I think the real issue, especially with gaming, that comes to my mind is predictability through government. The way they came, with this bill, which I understand was passed by, Rajya Sabha, Lok Sabha, in 72 hours and all, and still, of course, the rules haven't been there. So frankly speaking, it's not implemented and all that. But of course, the direction or the guidance to the big players have been move away, right? I mean, after establishing, after having the numbers which are, recognized worldwide, it's like fatal. I mean, those things needs to be understood, needs to be thought through. Very clearly. I think that is a big no-no, from a foreign, FDI perspective and all that. That will have big implication. That there can't be a stability, there can't be clarity in law in India. I think that's a big no. Is the first point I want to make there. I think we can move to other. Yeah, your research.
Yeah, I actually don't think sports broadcasting and exploitation is that complicated. Okay. It is very similar to the way media is exploited. It's just the same principles apply. It's the same laws. I don't feel like we need something specialized just for sports. It's not going to serve any purpose. The National Sports Governance Act is specifically just for the regulation of sports and for making sports better in this country. There are hits and misses in that act as well, but I don't feel like we need something new for broadcasting of sports. Like I'm not seeing any purpose.
Broadcasting to really say within the sports, right? There are several laws or several areas that govern. How do we kind of get them? So I think everybody agrees to what you're saying, that from broadcasting of sports is not a complicated thing. I think we're all on the same. I think it's more about we move to the point of sports as such, because there is esports, there is other sports, kind of there is a NSP, there is also the whole new Proga Act, right? Yeah. Which states that, there is something called esports, there's casual games, but needs a registration. If it's casual, there's no money, why does it need a regulation, right? What are you trying to regulate when something's actually free to play and there is nothing really, there's a harm? So what is that part over there which seems to be completely missing? So I think we are now trying to get to the point of spending the last 15 minutes on how this law really, kind of how these, pieces in the sports world can be kind of congregated.
Yeah, I think you are the right person.
Because this is all over. I can speak for it on 3 hours. Yeah. I can talk about it. I'll write a paper.
You'll have 10 minutes.
Yeah. That's right.
No, I'll just take a short, Samir. I mean, one of the point is like Shop and Establishment Act. No matter, you want to open something, there needs to be a registration. I mean, that could be, the background where the government is coming, even for, fun gaming. But I hear you, I completely understand. This is not business friendly, and we need to have, light touch regulations very clearly, and that should be the norm. So, yes, but, how do the government can ensure that these are business friendly? There is, more, interest, and there is, FDI, is flowing in. I mean, those lenses has to be applied, and these are the key metrics to my mind that has to be looked at it. And I think its lack of awareness, if I may say, is the reason, the right messaging is not happening. There has to be an industry unity there to take it up, to, advocate it in a manner, and there has to be policy, framework things on it, is how I'll put it. Thanks.
Okay.
I think one of the gaps which I see in the current framework is which is the nodal ministry. So it speaks of Youth and Sports Affair is going to look after esports, but the regulation is done with the MITI. So I think there is a big gap. That's the first point, because whenever there is overlap ministries, it's going to have a pain point for the industry stakeholders. The second important point is there is a concept of Online Gaming Authority of India to come, who are going to be the people who are going to write or be the clear, because today we see that all sports federation and bodies are working in a different sphere altogether. It's personal interest rather than the country or the sports interest. So I think who are going to be the people will make all the difference. And always in these models, I think the first mover advantage works. How, like I've always believed that whether it's media or it was telecom or it's in certain e-commerce domain, the first mover advantage, you and how you interact with the government, you push the envelope and get your norms as the industry norms. I think that will make the difference. I believe it's too premature and early, where I will say that you should bring more regulation on act, keep it as it is, let the industry flourish, and over a period of time, see if regulation is required, if there is aberration. Till that time, and I think India is predominantly going to, I think e-gaming is one aspect where I believe this could be AI technology, there could be deceptive issues. You are playing in e-gaming sports, someone is going to use a different software to go in and do certain things. How do you control those?
Bots is a huge issue here.
Yeah, so there, how we are going to do will make a lot of difference. How technology someone will use to disrupt the fairness of the game is something is a different ball game, fair dealing. Otherwise, I don't want any further change in regulation or rules to come in, which will further complicate the current state of things.
Okay.
So, I mean, we'll have to again see how these three laws, sort of enhance sports and develop regulations, because the NSJA has been brought with the intent that it's going to now regulate the federations to a certain extent, right? And that's the whole purpose of then moving from an automotive self-regulation of the federations with their bylaws to something which is going to sync with the regulatory framework. So I'm very hopeful that, at least when the contracts are being drafted, now there is some legislative backing which has been enacted for these federations to look up to in terms of regulating the leagues that they are going to, enter into. Also, with the broadcasting bill, if it is going to be enacted, It's going to change the framework for OTT platforms, and that's not limited to sports, right? It's going to cover the entire media, advertisement, entertainment industry to come under one act now, because we are under several acts at the moment, right? And those several acts, we have to rely upon the TRAI, because the broadcasters and the MSOs and the platforms basically come under the telecom regulatory ambit. Then you have to look at the press release, you have to look at government regulations which are coming per state. So all of this will sort of get aside with the broadcasting bill. And there'll be again one unified code where anything that is going as an e-platform will be to a certain extent regulated. So we'll have to wait and watch and see what the success of these new acts are. But it's a welcome step, I feel, because otherwise we were all over the place.
Yeah. Just back on the, sorry, Girish, just
Sorry.
one, okay, you want to go ahead first?
Yeah, I just want to make a point on the commerce side, because
Alright.
I have nothing to add to the compliance or the regulatory side. But I think because of the fact that cricket has taken off and everybody starts looking at it as a monetization monster in that sense, and everybody wants to latch on. The other sports, I think, still need a lot of commerce support. They need a lot of tax breaks, if at all, for people to start investing in it so that it goes into a space of development. Our football league is in a sorry state at this point, which doesn't really exist. We don't have one, a national one in the country, which is actually quite embarrassing for anybody who likes football. And the rest of them are in a worse off state, right? It's I think from a commerce perspective, a lot more needs to be done to be able to incentivize other sports. And regulation is something that can then kind of come along the way, because right now we don't have it. There's no point regulating something that doesn't exist. So I think there a lot more needs to be done. So whether it is foreign direct investment, like what Mohit was saying, incentives that can be done, tax breaks, etc. I think those are very important at this phase for any of the other sports to be able to kind of flourish.
I think additional aspect is in places like intense. I think places like Mumbai, where it's so land is scarce, right? We hardly have playgrounds and stadiums being built across. It needs to be mandatory. When you're making townships, playgrounds has to be mandatory as a reservation. In fact, we see a reservoirs. If you see the land mafias, they just take away the land banks. So a football as a game requires only a football to start with, right? So it's an investment is only in the ground. And if it's provided naturally in a town planning regulation, the starting point comes. So I think one investment for esports is the infra availability. If you look at a city like a Bombay, Delhi also, the amount of non-privatized infra which is paid, like in Delhi you have the DDA, sports grounds are so much there, in Bombay you hardly have it, right? So it's all monetized, you can't play. So just for example, if one has to play an evening cricket match of T20, the minimum cost is 50,000 rupees to book a ground and food. That's the rate in Bombay today for a 4-hour, 5-hour ground, which is next to impossible. 22 players dividing comes around 2,000 rupees per person. That's only less can afford. Whereas on a football ground, if you have just the availability is different. So I think the availability of infra is going to be a very important aspect apart from the tax ops.
But that's more on the physical sport, right? From an e-sport perspective, what is the infra you need? You need your computer and you can kind of sit anywhere and do it, right? And then so I think.
But just sorry to butt in there, but smaller towns don't even have a lot of that.
Yeah,
and I'm sure you're aware,
Yeah,
most of the best players that come into esports come from smaller towns where they all they're given is an internet connection.
Correct.
A high-speed internet connection. And for that's the infra, right? They have to go to like a cafe to be able to play there, and that's where leagues get formed and friendships get made, etc. So that may be something to be looked at as well.
Yeah.
So whether you give it free access to certain places or areas where you can go with free Wi-Fi and play, etc.
Yeah, unfortunately, the current act actually does not look at anything of that sort. So it's kind of, the way I look at it, the current act is really just what I would say, what would I say, just a hit back at what they thought was not to be done. And so therefore they just got a new law and they said, this is it and I'll tell you. But because it had to be put saying that, we need to also put what you can do, so it was put. And a classic reason why it seems like that is because the rules haven't come out and there is no sign of the rules. There have been consultations happened on that. They just heard it, but I don't think they even understood what the issue is. So I mean,
Samir, I want to flip the coin now. You have been moderating all across. Now we want to hear your views on e-gaming from two perspectives: the opportunities and the three challenges. I think that would be really helpful because given your expertise in that area, a lot of knowledge can come from there.
Okay, okay, that wasn't part of the deal, but okay. No, so I think, see, what really happened with this whole esports is really, esports was there. I mean, in the sense that, but in a very informal way. So especially if you look at the things like Call of Duty, Temple Run, all of it, these things have been going on. There have been smaller areas where people have been participating. I know of groups where, they pretty much start playing Call of Duty on Friday night and they play till Monday morning, right? And there's a lot of money in it. And there are these tournaments which are actually organized on that. And the winning team actually gets a very decent amount of money in that over the weekend.
Like pooled in resources.
Yeah. It's like the person who organizes, then people put in. It's just the concept when it comes to money is exactly the same, that the resources get pooled in, the organizer takes a bit of money, and then the rest of it goes to the winner or distributed, etc. So technically, I mean, and again, there's no formal data on this, but the informal data shows that every such tournament that happens over a weekend, right? The prize money is anywhere between 20 to 25 lakhs. That's the kind of money we are talking about. I mean, yeah, there are smaller ones, but yeah, and on average, if you see, it's like a huge money there. And so people actually turn around and play this. And again, no harm in it because it's really nothing which is really to say that money is being pooled in billions and billions, but this is more about, it's for fun, etc. But the reality is that whenever there's money involved, the stakes keep going up because from where it becomes a fun element to really a commercial element, I mean, the journey is not very far. I mean, if you see it and, if you go back to the whole gambling history, etc. also, I mean, just as a thing, the gambling really started where people put a friendly bet to say, okay, this much, and we kind of do it. And that was just to add a fun element into the game. But that became like the money became the more dominant part, and the rest of it happened. So in came the whole, the real money gaming. There is a law which says that skill game versus chance. I mean, we can talk about it for hours. But the fact is, nothing illegal on it, and that's how it was. So, but I think that's where a lot of the companies, a lot of the people actually exploited it and went beyond. And that's where I was talking about, you kind of, we push boundaries. But this wasn't pushing, this was like completely crossing boundaries. And I think a lot of the industry got it on themselves because there was continued advertising saying, Ghar jeeto, gaadi jeeto, ye jeeto, wo jeeto. I mean, it had to be. And then suddenly when you're talking about crores and then you're suddenly talking about, 35 crore or 40 crore people playing real money games. I mean, you would stand up and say, hang on, that's like 25 to 30% of the population playing. And if you take out the kids and kind of the aged who don't play, and you look at the real population, saying, hang on, my 60% of my population is doing this, and therefore where is my economy and where is my country going? And so that's how it came. But the knee-jerk reaction to that was that, okay, we have to get a law, which means that you can't just say I'm banning something, because with that you have to show there's a stick and there's a carrot. And so the stick was that esports is something we'll do. But unfortunately, there is no clue of how esports is done, and they have no clue of how it really can be grown and what the challenges are, unlike in certain other countries. Plus, so that's one challenge. So we didn't have the data, we didn't really go into the details, but we wanted to get a law. And therefore, without really getting to the basics, how do you really say a law that's going to govern something when you don't have the clue of what the issues will be? The second challenge really there was that ultimately, if you have a sport, right, now whether you take a physical sport, you take a e-sport, the only reason it will grow is there is money in it. You don't put money, people will walk away from it later. I mean, let's look at IPL. Let's look at, the World Football League. Let's look at anything. The reason why all of that becomes very popular is because there is money in it. And at the end of the day, as humans, everybody wants a profession, or everybody wants money, and that's what you're doing here for. Will you live your life going and saying, I'll just play football and let people see me? Nobody's going to come and see you also, yeah. Because that's really where it is. So the whole commercial aspect can never be disregarded, right? So that's the other second challenge. And in this particular situation, the way the law has come out, there is no point about the commercial aspect and how it is. It just says you can do e-sport, but Again, how does the commercials work? What is really now the distinguishing fact between a real money game and non-real money game? Does it mean money in, money out? But the reality is there is money in, money out everywhere. You look at some of the competitions, people put a entry fee to go and compete in it, right? In a football tournaments, I mean, there are so many of these football small things happen. They all pay some 10,000 rupee entry, and then there's one winner in the end, right? So there is money in and there is money out. But what's the definition of gambling? So that's your second commercialization.
Just thought if you could clarify on esports, can there be some media rights sort of a thing? Because I understand like a game of chess.
So that's the third part I'm coming to. That's your third challenge, because when you put all of this, again, if you don't do monetization in the manner of winning, there has to be monetization in the manner of display, show, etc. Now, how that media rights, where it's owned, how it will get done, I don't think they've talked about it, which is where the whole gap between what current laws say and sporting is, there is a mismatch there. So that's the third challenge really. So the fact is that started from somewhere. It was a basic way to turn around and stop a certain thing, but turn around and put something else because you had to give something else. But ill thought out, and then at a point where I think now they're rethinking, which is why the rules that are supposed to come out in 15 days, it's been 4 months and we don't see a end to it.
The status of Supreme Court?
Sorry?
Supreme Court hearing on the challenge?
Nothing's happening.
Listed in Jan,
It's listed on 21st Jan, but the fact there is also, if you see what happened in the last hearing, there's a new googly that came in. So the matter didn't come up before the actual bench. There was an early hearing application put before the Chief Justice. The googly came out saying, oh, we are still deciding whether constitutional challenges will have to mandatorily go to 3 judges. So all of that now stops. So till we decide the larger piece, this is now a new Chief Justice comes and says, I have to first take that decision. Then I will decide where the matter goes. So it's all in limbo. We don't know where it will go.
Sorry, I thought I'll just clarify. When I meant, like a game of chess can be shown, through TV broadcast and all that, digital streaming. So e-gaming, do you see there's a potential there? I'm just wondering, people playing on a screen, people playing using a joystick?
Absolutely.
So if even the proposed bill doesn't talk about it.
It doesn't, but it depends on the game also. I think the issue there is not every game will be in a way broadcastable to the sense that people will have interest or not. For example, let's take Call of Duty or let's take a car race. Nobody wants to sit and see people playing a car race on a computer. On the other hand, chess is something that because, it is showing moves, it is showing there's an interest. Cricket is a classic case, right? Why is cricket or football still something that's broadcasted more than, or tennis? Look at tennis, right? But an e-sport there, some things could be, but not all.
No, sure.
Participative.
I think Twitch is a huge platform. There's this platform called Twitch, where it's a screen, and someone's playing it, and you are just watching someone play a game. It is massive. And that the number of people who watch Twitch and who are influenced by Twitch, that is a huge media opportunity.
What's that number, if I can ask? I'm not very clear on that number.
I'm pretty...
Actually, there's also a YouTube channel, I know, because my kids watch it. It's not some intellectual nonsense. I'm just adding to my point. That there's also a YouTube channel. There are 23 million subscribers to that channel, and all they do is just watch someone playing that silly Minecraft. That's Roblox. No, not Roblox.
That's a different generation. It's targeted towards different generation.
Sorry, there's something to be said.
As what I see on YouTube, there is this channel called Mr. Beast Gaming. He's very big on, he plays a lot of games, including Minecraft, Call of Duty, Buckshot Roulette. And this is highly broadcasted. He gets upwards of 50 million views per upload.
He's the most paid YouTuber.
Most paid. And even on Twitch, as ma'am rightly mentioned, Twitch also has now contractual dilemmas with other lot of gaming channels and a lot of people who are into gaming. So this also is something that has not been discussed, or rather not been regulated also, based not just in India but also abroad.
Mr. Beast actually sort of launched something like a Squid Game, which was aired, and it's called the Beast Games. right? So he's at another level of online gaming, which I think India will take some time to sort of build right now.
But in fact, the fact is that, I think we got more students there saying, but the fact is that a lot of this is still not there in India, right? And while YouTube is a global platform where people go see it, but if you look at it, there is no provision in the laws today for how this will develop. And that's where a big gap is, because I don't think we even see that as a potential.
I think that the permission is there. That's my understanding. If there is no banning, like online money games are banned per se, if these games are not
I think
explicitly banned, then we believe
no, I don't think it's about no permission. I think it's about the fact that at some stage there will be a monetization of it and how they deal with that.
India has not wrapped its head around all of this.
Exactly.
Actually come in.
Right.
The laws that have actually come in is trying to wrap up what is not there, 20 years before. So I think, again, coming back to the same point, it's a start, and we can hope only better from here, if not the worst. So, yeah.
Sure. No, so somebody at there.
Yeah, so I wanted to add on to, again, e-gaming so I've frequented a lot of circles. We used to, after the Battle Royale genre, that's Fortnite, I think people have heard of this. Yeah. A lot of new games have come up where there are actual discussions on strategies with like going forward, how to play the game, how to like take into account various elements which can affect your game and then like win, right? So I think esports right now has become a huge thing, and especially on Twitch, and there are again tournaments, prize monies, Red Bull sponsors, like a lot of brands like sponsor gamers to like play. Yeah, so
No, just to add to that, I think from an influencer perspective, India is already there. I think the awareness is not in groups that are above a particular age at this point. To the room, I guess, because, we do a lot of deals for influencers that are actually gamers. And there's a gamer called Ninja, for example. The guys may be knowing him in the room. And he plays very specific tactical games, etc. And for posts, to do posts online, so whether it is on Facebook or whether it's on Insta, etc., they charge upwards of 10 to 15 lakh rupees per post. Now, this is not a small amount of money, right? They are roaming in circles which celebrities currently don't even have that kind of money, who are acting talent and things like that. So this space, when it comes to monetization, there are few places. One is obviously the game being broadcast. Imagine for a second that you could organize a cricket match, you could shoot it, and then you could broadcast it, and you yourself could monetize everything on that broadcast. That's what you can do with an ecosystem. You literally just need to log on, you need to play the game, you need to record your entire game, and you can just stream that onto YouTube, or you can even do a delayed watch of it. We've watched India play Pakistan matches, and we watch it on repeat sometimes, right? There are games like that you can literally go and watch somebody play the game on repeat. And those views are monetizable. YouTube, you can monetize that, and the individuals themselves are talent which are monetizing their presence. So there is definitely a lot of that already happening, which is unregulated. Yeah. I do agree to that, because the games themselves are currently doing it because they want adoption. So to them, it's not really, but at some point, there's going to be some kind of pushback, because even the platforms currently are not regulated on that. They are not really paying any kind of a fee. The games are all right. The guys currently monetizing it are the players themselves. But that's a huge space, and it's already pretty big in our country.
Just want to add, similarly, merchandising is not really has been monetized in India the way it has been done, right? So there are areas where we are catching up. Maybe there's lot potential, but for whatever reason we haven't. Then there are areas like, the fastest delivery under 10 minutes in India. We are the world leaders probably, for whatever reason. So different, of course, segment, different, industry from that, yeah.
You had one point in your question list about monetization. Yeah. It's the ad, subscription and merchandising. I think that's so, because India has been totally driven around ads so far. It's not been around subscription revenue because nobody willing to pay. And merchandising is still coming up in areas where you have interest. So I think that's one area one needs to look at.
So I'm going to actually, I know we're also time, and I've got already an indication that we're going to get into Q&A, because I'm sure
I think we need to give an opportunity to those.
questions to ask. So I'm going to open that up. Yeah, please.
I have a couple of questions for the panel. I would want to begin with the question that esports is now deeply dependent on streaming platforms, as now we've discussed recently, and that digital media is also playing a very big role in it. So how does this change the way we think about broadcasting rights as compared to traditional sports?
So traditional sports was largely offline, and the way we looked at sports until I think 20, 25 years back was a complete different set and a different ball game. Today, I think after a few years, all the sports is going to shift online, right? So as I mentioned that currently we don't have one law that basically regulates what the OTT platform is doing with respect to the e-gaming arena, right? And in that sense, I'm looking forward to what the broadcasting bill is actually now going to do with respect to regulating Netflix, your Prime, Amazon, your YouTube, all of these platforms which are actually giving the e-gaming arena a different ballgame altogether. So if you ask my personal view, I think this regulation is very much needed, because currently, as rightly mentioned, if e-gaming or the e-gaming sports arena has a miss, where there are things which are being misused in terms of how it is operating, right? The e-platforms or the OTT platforms completely put their hands up and they're like, you need to get a court order for us to do this, to do X, to do Y, where the content itself published, in terms of e-gaming may not be, things that should be watched by people who are, say, underage, right? So the whole issue on PUBG that had happened, and it had escalated to another level, where it started with a small campaign of parents coming ahead and saying that, we don't want our kids to do this, what they're doing, 24 hours logged in, seeing somebody else playing PUBG, or there are 2 to 3 people who are gaming on PUBG and getting their winner chicken dinner kind of a situation, right? So today I think it is far more equipped in terms of how esports is looked at, and the broadcasting bill, which is yet to be enacted, will reshape how OTT platforms are now going to get e-gaming into the zone. So
In fact, one of the pieces here is that it's yet to be enacted, and the way things are moving, I think they'll have to relook at it before they actually get it to a point where it needs to be, right?
I think the answer to that will be two stage. Number one, is that e-gaming is going to be monetizable or not? To start with, the guy is going to give the rights, will not going to charge anything. You have to first make the platform popular, make it monetizable. And then the game will come, how you do it. And that would be the standard thing which you give at the opportunity based. The important aspect, as told by Nadia, is the important thing is in those opportunity, are you using any products, like are you promoting a liquor brand over there? Or you are selling something or putting a misleading ad over there? Those aspects will come up, and I think over a period of time, the existing laws and domains will help, but later on, it will be a check and balance. The organizers and the broadcasting rights guys will think whether it's right or wrong and take it forward. So it's going to evolve. It's not going to be an overnight journey. As you saw during the Kingfisher days, that their branding they used to do for themselves, you will have those typical,
just want to add one point to it also. I mean, it's evolved to a certain extent that actually RBI has certain regulations on how fungible tokens are being used. So, your games that are there, they have these coins that you win. And from those coins, you can purchase in-app things, right, to equip yourselves to play better. So there's a whole master direction on how fungible tokens are also going to be used and how equipped. So it's not that the state is not thinking. The state is thinking. The only thing is that different bodies are thinking differently, and it's in various fragments at the moment. So again, it's evolving, right? And we have to evolve with the time.
I have one more question to the
Please go
one.
for it.
So now that most students here are in their third year and almost having to now select our specializations. And as industry experts in media, sports, entertainment law, what would you recommend our students to focus and to be prepared for once we step into the legal fraternity and probably into this industry?
One general rule I have followed is you are a legal profession first and then you go to an industry specializations. I worked across industry. When you start a new job or a new service, you go and understand the basics. You take 3 months to become the basic knowledge and 6 months to master the subject. So whether you move transition from say a media to telecom to airports or to sports, you need to have the fundamentals of law first. In my view, you're never an industry expert. You start with a legal expert. So understand the various nuances, Competition Act, contracts, constitutional, all those aspects, and then you go back and do that. So that's would be generic advice.
See, I believe the success in a legal profession is more linked to the passion, what you're most interested in. So while you have your internship opportunities, try different sectors, do some internships in a manufacturing, do something in fintech, in media, and see what interests you most. Because at the end of the day, you don't have to get bored doing the same work over and over again. You should look forward to making big in the particular industry. So the earlier you find your passion, what you're most interested in, that's what's going to ultimately lead to your success.
Yeah, I have one thing to. So sorry. I feel like what Shrivals and all said, but if you're asking specifically for what specializations you have to think of, I'm not sure whether these are elective subjects, but almost all legal subjects are based on 3 or 4 important laws. One is your constitution, one is contracts, one is IP. IP typically ends up being some amount of electives, and the last is evidence. So if you are able to master these 4 and take any electives that cover these 4, you should be good.
So I would say go wide and go deep in at least one, right? So don't not do something because you're like, no, I'm just going to be an IP lawyer, but I have no clue about anything else. I think you should always use that. So go as wide as you can. Please make sure you study enough tax as well, because that seems to be something that everybody just very conveniently avoids, saying, no, I'm not a CA, I'm going to be a lawyer, right? The implication of that when you do commercial transactions, you will not realize how important those are. So go as wide as you can with everything, but go deep in at least one.
I would like to add to this thing. Yes, tax and of course commerce background and a little bit of financial knowledge is a must. Any field, any law, but yes, that is a must.
So 25 years back, along with my law, I did a 3-year PGD, Diploma in Business Management, while I was studying law. So it gave me a lot because I want to go to corporate. So you should look at not only field, as rightly suggested, commerce, tax. If you get a general perspective how corporate operates, that will give you something different. Maybe do something on that also.
Yeah, in fact, I was going to say something similar, which is, especially I think if you join, corporate, so either you'll join a corporate or you'll be advising a corporate. The fact is, how do you see yourself as enablers? And I think in a lot of times, lawyers are seen as the people who tell you what you can't do. You can't do this and you can't do this. But I remember my experience so I'm not a lawyer, by the way, so I'm probably the only one here without a yes. So I remember as a young brand manager, I was in Hindustan Lever at that time, so I went to somebody who was very senior in law, and he would approve artworks and things like that. So I went and told him, this artwork is there, and I think artwork violation was, I think directors could go to jail and things like that. Huh? So I went and he said, Manisha, you do it. If there's anything wrong, I'll take care of it, and some director will go to jail. You won't go to jail. So it was, I'm just saying that, obviously he would make sure that, there was nothing wrong, but I think just the, the orientation of enabling what you can do, I think is a good perspective to keep in mind.
So, 2 cents from my side. I would believe what Prashant said is extremely important. Always understand yourself is the first thing. Don't just follow the crowd. Knowing yourself is the paramount first. Second, I completely agree what Shrival said. Go broad base. And my 2 cents there is I have had a litigation background and it has helped me immensely. Because when you are doing a transaction or advising a client, you need to know what happens in court, how and what the judge will look, how the law will get, developed tomorrow, or how and, eventually. So that knowledge is paramount. Of course, somebody has complete aversion to, dispute, to courts and all, that's fine, but getting a little bit of litigation background is extremely helpful, year or two, if at least, as I would say. Of course, try and know yourself, and it's okay not to know today. You will probably know 2 years, 3 years, 5 years down the line. So go with your calling is very important. Let me just also add, law doesn't only mean legal profession, meaning the lawyers who do transaction, go to court. It also means people like Jenna, who has moved to very different thing, who does, is part of the content creation, podcast that she has, daily lawyer. So, and at time, it may not come immediately. Know yourself, be true to yourself. I think that's what matters, not getting bogged down and don't follow the, crowd mentality, your herd mentality. That's all.
See, law is not just black and white. When you're dealing with clients or corporates, it's a shades of gray, which you have to interpret to black and white. Knowledge of business is going to be the most important thing. How an industry operates, what are the nuances, and one example I give to in-house people, which is basically the business side people. You go to a crossroad, there's a huge stone lying over that. The business wants to know, should I jump over it, go from right side, left side, or come back? Unless you know the laws around, the judgments, the industry issues, you not advise. And in business, the most important thing which I find, the sales or the revenue stream wants to jump into a well all the time. You can't say no to them. So what you have to do you have the ropes and mechanism to pick them out? You should know that. So I think your advice and your business sense will do a huge lot of things to you.
Sorry, just want to quickly sum this up. I have been a visiting faculty professor for about 10 years now with a lot of colleges all across Bombay. The only thing that I want to tell you is just be focused, have the passion, and just keep reading. Just don't stick yourself to books. Don't stick yourself to the syllabus, because the syllabus is eventually not going to help you. Accept the fact that you will get a degree. Go beyond your syllabus even when you are studying law, right? That is, the more the exposure you get, the better you become at everything you do. So.
Read full judgments, don't go at IICA. That's the biggest thing I have seen nowadays. You need to see today at our time, I'm saying 25 years back, we used to have an MTNL connection at home, which used to work at 25, 28 kbps speed. And we used to wait at 11 o'clock in the night for a free service to come to download our files from the net, right? So today you have technology and information, all the High Court judgment, Supreme Court judgment come instantaneously. Morning at 10:30, a judgment pronounced, at 10:45 it's there over there. I think the concept to read, go in detailing, and make notes is something which will always help you.
Just to add, as rightly said, practical knowledge is the key part of it. And frankly, it's paramount in today's world. Your syllabus is just structured for today, probably will not envisage, like generative AI, the way things have evolved. None of us studied that, right? I mean, there are a lot of things that you guys are studying, will evolve tomorrow and all that. And frankly, real honest truth, my son is in 8th grade and I tell him, and if you don't want to study after 12th, I'm cool with it. The reason I tell him is, first of all, he himself takes a lead. He's focused about it. Second thing is, and I truly believe, real knowledge happens, or real gain, real experiences at work. Be focused with that. Try and have internship. Try have those stints. Broad base, in fact, will help you to learn. Read. YouTube is the best teacher, if I may say. Sorry, professors over here, but that is the truth. There's wealth of knowledge and education all around you. Be curious, be inquisitive. That is the underlying part of it. Thanks.
Okay, should we?
Sit down, just 1 second.
So much excitement for your
I know. I'm just wondering.
This is not just for you. This is not just for you. This is for everyone, guys. You are in one of the most lucrative professions that you can be. Okay, and yeah. But on the other side, this is a profession which is the only profession where you can't put your guard down ever. This is the only profession where you are questioned on every step that you take. This is the only profession that you are challenged and you are judged. You go to a doctor, doctor writes a prescription, no one is judging whether the prescription is right or wrong. One argument you're making in court, you've been opposed and you've been judged. So for that, you cannot put your guard down ever. And how you don't put your guard down? You have to work hard and not AI hard, literal hard. And I'll give an example. And this happened so people use ChatGPT, and I hate ChatGPT, but sorry, and to the youngsters. But there was a phrase which is used in legal documents that you approach this court with unclean hands. Someone uploaded that and asked for a reply, and that reply was filed in court. And in the court, that phrase was dealt with. I deny that I have come to court with unclean hands. I wash my hands every morning, etc., etc. And that was a ChatGPT answer, and that was filed in court. So even if you're using ChatGPT, guys, or even if you're using some AI tools, you can't get away from going into the details. And it's just that you are in one of the most beautiful professions. I would not call it noble, but but a beautiful. The system is made for lawyers. Understand that the entire system is made for lawyers, but there is no get away from hard work on this. So. Yeah.
Thank you. We'll move to the next question, but don't get overwhelmed by this. These guys just being mean here. Live your life, enjoy it. It's okay.
So my name's Teeth. I'm in the second year. So I was wondering, since I just completed constitutional law a few days back, so looking at the regulations and the discussions that we've had, we've seen legislations being passed which are more or less sort of binding agency of businesses and commercial places. So if there are any experiences that you guys would have gone through where you would have tackled such legislations by the government, I'd be happy to hear that. Like in the sense that, for example, Sakal Papers, Bennett Coleman, like in those cases where the legislations passed by the government were sort of compromising the agency of the businesses, in the sense that, for example, in Bennett Coleman, there was limitations on the amount of pages that you could publish and things like that.
Unfortunately, I'll say this on behalf of most lawyers, it's great because you have the opportunity to challenge it. But at the same time, the reality is most legislations that come out actually will have some kind of piece which will be a problem from a business perspective. That's not because they do it deliberately. I think they don't understand the way a business moves. Plus, in reality, this is my personal view, is that by the time a legislation comes, the world has moved. And that's been the history always. As a result, there is always a catch-up to do, right? And I mean, to me, I take it as a big opportunity because essentially the fact is if there is a constitutional problem, they have violated something and it can be constitutionally challenged. That's where we come in.
Yeah, just to add, I think what you are referring to is, international news is kind of, there is, ceiling what you can cover. Not otherwise, I would believe.
I think what he's referring to is that on an overall legislature perspective, there'll be something or the other which kind of, becomes a issue, and therefore from a constitutionality perspective, do you challenge and what options exist?
So I think when you are part of business, the bigger the challenge becomes, you start going to bigger law firms and constitutional experts. So give an example, telecom industry, there used to be a service tax of 5%. Subsequently, the government said, I will impose a sale tax on the SIM card also, on the value of your revenue. So it's a constitutional problem. So you take 2G scam happened, it was all about whether policy was right or wrong. So there was the cancellation of license plus the criminal side of the criminal jurisprudence of that. So you take any industry today, every industry will have at least 5-6 issues which will either from a business or a constitutional or a tax perspective. Every industry goes through it, and the bigger the industry becomes, the more the value it adds, it comes in the eyes of the government, and you will see a newer happening. So if you look at it, online betting was one thing because it grew. E-commerce came. If you look at 5 years back, when e-commerce came, lot of issues came on whether they should be liable to a VAT, whether they are form of the CCI issues. So I think every industry, as it grows, it comes. Whenever the monetization comes and when the industry starts, usually compliance is at 50-60%. There are black holes and later they come to bite you. So I think one of the learnings which we see from a startup or new industry, try to be as compliant the right side of the law if you want to grow and not get caught by it. So I think issues will always be there. Constitutional issues will always come, or a tax issue will come in every business. Usually they are sidelined or it is not a big opportunity from both sides. They go down the curve. Otherwise, every industry will go through this point.
Okay, so any other questions? Because I think we'll need to wrap up here at about 1:05. Okay.
Good afternoon, everyone. I had a question about self-regulation, especially in the media field and with media firms. So I think a point was raised where they said, like, I don't remember, multiple people had discussed this point, but self-regulation was ultimately like self-interest for the people in the industry, like the firms in the industry, the studios, production companies, whichever organizations they are, ultimately like if they're given the power to regulate, they'll mold the regulations and legal framework to benefit themselves. And let's say artists or celebrities, performers, they may be denied their moral rights and other rights. So my question was, is there a more democratic process where again, these other stakeholders, their rights are preserved, as well as at the same time, sensible legislation, which again, another point which was raised was that firms and production companies have skin in the game. People in the industry, they know what they're doing. They know what's meant to be done. So is there a process where all somewhere between self-regulation and government? Yeah.
So there are two aspects which we discuss. One is self-regulation, where we see a government taking an action against us. So we are saying as a body, we want to decide on those issues. Second is intra-stakeholders disputes. That never comes in self-regulation. Why come, and I think Manisha and they can say from an ASCII or from an IBF perspective, is usually the issues which are going to be between a government and you in terms of, say, a programming code violations. Those we take as self-regulation to control, because we believe as industry we can be better judges and put a process in place. Intra-stakeholders fights between various stakeholders will never come under self-regulation.
So what is self-regulation? I think we want to clarify here. What is self-regulation is multiple people within the ecosystem, multiple stakeholders within the ecosystem, all of them agree together democratically to be bound by certain rules. So they are all together involved in the drafting of those rules, in putting up the self-regulatory body, in monitoring. ASCII is a great example, and Manisha can speak in greater detail. So your question was, when we say self-regulation, it's not like the big dogs who are sort of not taking care of the smaller dogs. It's not like that. So that is one, and so that was the perspective from which the whole discussion around self-regulation was conducted.
So let me give a practical example which will help you. Imagine BITS Law School didn't have any rules and regulation. Dean says, you students, you drop something that you would want on campus. Should be rules and regulation, meaning how the classroom should be conducted, what should be the timing, what you should wear, how your, if you have boarding, how your rules and regulation. So imagine these students coming together, thinking of it, what will pass the muster of Dean eventually, right? You don't want Dean to strike it down. You don't want Dean to add more to it. You would like to put it in a manner which is, will have a buy-in from him. That's exactly what we are talking from an industry perspective. We want to come with rules and regulation with that specific industry, for example, media, come with rules and regulation that government will broadly say, looks fine, I don't need to intervene, let these people govern themselves based on the rules and regulation. If that helps.
Yeah, and just to add, I think, you can have intra-stakeholders also. I mean, for example, at ASCII, consumer as a stakeholder. But the purpose, in a sense, of the organization is to make sure that the consumer is protected, again, not for selfless reasons, but for the fact that when you protect the consumers and they can trust advertising and they can trust businesses, you build more trusted brands. But yes, so we look at consumer complaints, for example, and I mean, in that sense, self-regulatory is always, I mean, you know, we have seen sometimes the government saying, ye to industry wale, and industry wale bolte, ye to hamare pe bahut danda chalate hain. So, you know, you have to have that balance of how you do it. And I think importantly, one of the things about self-regulation is that while you may be funded by the industry, you have to be independent. You have to establish a procedure which is independent. So, for example, in the case of ASCII, the jury that we have does not report to ASCII. We cannot interfere in the jury. So while we appoint the jury, and again, there are some benchmarks on how these juries can be appointed. For example, we have majority civil society in the jury versus industry. But the fact is that the jury makes a decision, and even if we don't agree with it, I mean, we can't do anything. I mean, it's the jury's decision is the highest decision in ASCII. Those are ways of building independence, which is where, let's say, as in his example, the dean will kind of say, okay, you know, they're doing a fair job. You know, they're not doing it just for their own benefit, which is to the detriment of other things.
Yeah. So Manisha, you could just kind of correct me if I'm wrong. In the jury, you know, what she spoke, for example, if, you know, it's XYZ media company, which is being, you know, brought, a complaint is filed, the member from XYZ company who is part of the ASCII, you know, will not be sitting. So that helps, right? Yeah. So there's no bias as such, clearly speaking.
I'll just add one more point on that. I think this is more from an industry perspective. The idea of a self-regulation, actually, if it really has to succeed, has to be the overall interest and growth. And you know, just to add to what Manisha said, if I put a regulation which does not protect my consumer or my customer, then it is no use, because it may help me, but unless I can protect my consumer, who will then continue to be my consumer for a long period, my business will die. So self-regulation is not just about, you know, putting some rules together. It's about how the whole ecosystem can benefit and grow together.
Walk the talk is most important.
Yeah, absolutely. Yeah.
So you suggested the co-regulation method, but then how would... Oh, ma'am, you suggested the co-regulation method, but then how would it take into account the industry unity that it's lacking as of now? How would you choose over the self-regulation method?
Yeah, so I think industries that are not united don't have self-regulation. I mean, it's that simple, or it fails.
Yeah.
So for it to be credible, you have to agree on a few points. And as you say, you can be competitors in the market. But I think there are some basics that, like for example, in advertising, which is what I look at, there is a basic understanding, yes, that advertising needs to be something which is trustworthy, because if people don't trust advertising, you are going to spend, you know, one of your core pillars of your business, which is how do you kind of talk to and connect with consumers, is now no longer working for you efficiently or effectively, and that's a loss to the industry. So, yeah, but if there is no industry consensus, there is no self-regulation, then there will only be regulation.
In fact, I'll give you a classic example. The online gaming industry is exactly that. Because there was a whole lot of piece that people wanted to get into self-regulation. But there were also the bad actors who said that every game now becomes a skill game. And therefore, you know, all of that happened. So absolutely, I mean, what Manisha has just said is exactly the point, that if the industry is not aligned, self-regulation doesn't work. And there will be, in fact, I would go extreme, there will be no industry, forget regulation.
Two important things I would say to all: read the ASCII code as an understanding, and also few judgments or the rulings they've given. Basically, two types of issues happen. One is misleading ads between two competing players in the industry, or a customer files a case, like, you know, typical case, Fair and Lovely, whether the color changed me or not, that was one. And second would be when misleading ads of toothpastes or soaps, etc. So please read these, and they have subsequently been fought in high courts, etc. So an understanding will come how self-regulation has helped the industry. You will get a very good perspective from there.
And most of our case recommendations are there on our website. So I mean, we put all of it on our website. So it's ascionline.in.
So okay, I'm conscious of time also. So unless anybody has any other question, we can try and conclude.
I would now like to invite Ms. Vaishnavi ma'am to come and deliver the closing remarks. Thank you.
A warm good afternoon to one and all present here. So I wanted to thank all of you being here and gracing this occasion and the roundtable conference. We got a lot of valuable insights. As we conclude this roundtable, on behalf of BITS Law School, I would like to sincerely thank everyone for the thoughtful thought and engaging contribution shared through the discussion. Our theme, content, commerce, and compliance, is especially relevant in today's evolving media, entertainment, and sports law ecosystem, and the insights shared today have added real value to the conversation. Our aim was to provide a space where industry leaders, legal professionals, and academia could engage meaningfully. Thanks to your participation, this has been a very engaging and productive exchange. The discussions from this roundtable will now be taken forward through a white paper to be developed by our faculty, ensuring that the ideas shared here contribute to a wider legal and policy discourse. I would like to once again thank our distinguished speakers for generously sharing your time, expertise, and perspectives. A special thank you to Mr. Anand Desai for his keynote address, our Dean for his constant support, and our faculty, students, staff, and the IICA team members for making this event possible.